Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1041 et al. Pacific Gas and Electric Company petitioner versus Federal Energy Regulatory Commission. Ms. Goldenberg for the petitioner, Mr. Ediger for the respondent, Mr. Bain for the intervener.
Good morning, Ms. Goldenberg.
Good morning, Your Honor. May it please the court. The class-based approach that FERC adopted violates the plain text of Section 824KH2, which is incorporated into the tariff. That approach would vastly expand the grandfathering exception to the ban on mandatory retail wheeling, allowing, as the Commission has previously said, grandfathering covering every consumer in San Francisco based on some kind of unspecified resemblance to a consumer that San Francisco served in October 1992. There is no textual basis for looking to a category or class of ultimate consumers. The orders here don't supply one. My opponents have not identified one, and that's because the statute refers to a discrete, particularized consumer provided service on one particular date.
Before we get into the merits, can you help me understand what injury your clients currently are suffering because of the tariff? Because the tariff is no longer in existence. I mean, that's expired, right?
The particular tariff at issue here, yes, there's another tariff, a successor tariff, that's come into play. And so the reason that this is very much a live dispute is that as to that other tariff, there are still legal disputes outstanding that the parties are working through. And in particular, the parties stipulated in the FERC docket with respect to that other tariff in August 2022, they made a joint motion to stipulate that the Commission granted, saying that what was decided in this case would determine whether it was just and reasonable for PG&E to remove from that next generation tariff the language that's at issue here about grandfathering, referring to the eligibility criteria of the statute. So that's one of the reasons that this case is very much alive. And then I would just add that the court rejected a mootness argument in its last decision in this case in 2022. One of the things it said is that FERC has equitable authority to afford relief for prior tariff violations. So that would be another reason why this is very much a live dispute here, even though this particular tariff isn't currently in effect.
What is the redress? I mean, if we were to vacate the orders that are before us today, how would that redress PG&E's injury?
Well, the PG&E made a compliance filing before the Commission that changed the way that it was treating various delivery points based on the Commission's order in this case. And that compliance filing is something that the Commission hasn't acted on yet. And so if this court were to rule for PG&E, that compliance filing would go away and PG&E could return to the way that it was treating delivery points before FERC's order in this case. And in addition, as I say, in the next level, the next generation tariff, the dispute would be different. And
would PG&E be entitled to compensation for having provided service, to locations where if this court were to agree with PG&E, it wasn't required to provide service?
PG&E hasn't asked for compensation, but again, a change in the way that PG&E was treating these delivery points has occurred as a result of the Commission's order. And when this court rejected the mootness argument in the last appeal, one of the things it looked to was not only the effects with respect to this particular tariff, but also the fact that the next tariff is not yet fully in effect because there are legal disputes between the parties that haven't been resolved. And the same thing is true here. Those legal disputes remain. So in that sense, the next tariff isn't fully in place. It's not fully accepted by the Commission because there are these legal disputes between the parties, one of which is the question of whether this particular language that's in dispute here is something that can or cannot be in the next tariff.
Can we have jurisdiction simply because FERC indicates that it's waiting for our decision? Does that make something a live case or controversy?
I don't think that alone would make something a live case or controversy, but that's not at all the only thing that's going on here. There will be real effects in the world with respect to this tariff, which is still a tariff before the FERC fully accepts the next tariff. Well, there are still legal disputes ongoing with respect to the next tariff. And there would also be effects with respect to that next tariff because of the stipulation that I mentioned. And in addition to all of that, and this was something else that this court relied on in rejecting mootness in its last decision, FERC could order equitable relief of some kind for prior tariff violations. So there's an effect in the world for that reason as well. And San Francisco, in its complaint here, did ask for equitable monetary relief. So for all of those reasons, I think the same reasoning that the court gave when it rejected mootness last time around applies here as well. The situation with respect to the next tariff really hasn't changed significantly since this court's prior decision in 2022. So I'd like to start with the text, if I could, and then I would like to spend a little bit of time talking about our arbitrariness and capriciousness argument, and then also spend a little bit of time talking about what's really at stake here in this case and what's not at stake in terms of what the effects would be in the world of this court's ruling. So with respect to the text, the word class and its equivalent doesn't appear anywhere in this provision.
Let me interrupt you for a second. I'm assuming that everyone has triple checked this, but there is no definition of consumer in the statute.
Correct.
What do you think consumer means? Rather than debate about what class means, tell me what you think consumer means.
Consumer is the end user of the power. The ultimate consumer is the end user of the power. So not somebody who's going to transfer the power, sell the power. There's a person who's actually consuming or using the power. And I don't think there's any dispute in this case. There has never been any dispute between the parties. FERC has never said otherwise. That's everyone's understanding of what an ultimate consumer is, the consumer of the power. And you can see from the statutory provision that that's what Congress is getting at here, because the provision requires for the grandfathering exception to apply, the ultimate consumer to have been provided power on a particular date, October 24th, 1992, and to be the consumer of that power, to be the ultimate consumer of the power.
The statute has, it says an ultimate consumer. So read literally, that would be one person. And so once we all agree that we're not talking about one person, we're talking about classes of consumers, whether it's the class that you propose or the class that the other side proposes.
I think there's a big difference between saying that the term an ultimate consumer can apply to many different ultimate consumers and saying that we're talking about a class or category that's defined in some way by characteristics, which is what the agency has done here.
But your definition is also a class of consumers, the ones who were being served at that time.
Not as class is being used by the agency here. And I think this is a really important clarification. Class is sometimes used to mean a defined group of people who experienced something, right? Who were provided power on October 24th, 1992. If you were doing a class action, you would use class that way. What the agency has said here is something extremely different, which is that class is a category, a broad category of consumers defined by some characteristic into which people may or may not fall. But the characteristic is not the statutory one.
I understand what the dispute is about that, but your textual argument, it seems to me, is that you must win because the statute supports your view. But once we acknowledge and understand that the statute has to be talking about some class, whether it's the class they say or the class you say, your textual argument is greatly weakened.
I don't think so, Your Honor. What we're saying is that an ultimate consumer is singular, that the Supreme Court has told us this, refers to an unspecified, particular, or discrete countable thing. And yes, when you look at the Dictionary Act, you can see this as well. When a statute says singular noun, it can refer to a lot of different people or things. And you can also see this from the Supreme Court's decision in Nice Chavez, which we've cited in our brief, where it was a notice to appear. And what the court said is that is a singular thing. A notice to appear can go out to many different people.
So if we think the statute just means ultimate consumers, because we're talking not about one person, how does that affect your argument?
So I think, again, our view is that an ultimate consumer is any one ultimate consumer who meets the statutory criteria, who was provided power on October 24th, 1992.
But my question is, if we read the statute as an ultimate consumer, it's just a way of saying ultimate consumers, which I think is a very logical way of looking at this. How does that affect your argument?
I don't think it affects it very much in the sense that it's still very different than the class-based approach, because if you're talking about multiple ultimate consumers, you can look to see, was this ultimate consumer in front of me somebody who was provided power by San Francisco on October 24th, 1992, and was this ultimate consumer someone who was provided power on October 24th, 1992? And everyone, you can think of that as a class if you like,
I think
but everyone has to qualify.
I just don't see why we necessarily should. I just don't see what supports your argument.
Well, again, I think the way that the statute is written is very clear that it says that the consumer, the ultimate consumer and ultimate consumer as to whom the wheeling of power is going to go, right? The power is going to go to that ultimate consumer. As to that ultimate consumer, such ultimate consumer, there has to be a showing that such entity, which is here San Francisco, was providing the service on that date. So you have to match them up.
In your view, there's that sort of hypothetical from Suffolk County where, you know, two neighbors are receiving service, but one day on the day in question, the power was out for one of them. They would not qualify for grandfathering in your view.
I think that particular hypothetical, there would be a question of what it means to provide service, actually. That's not an issue in this case. Nobody's briefed or argued that. You could argue, I suppose.
But you would say that person could get service as a matter of being an ultimate consumer, even if they weren't receiving service that day.
I think if that person was a customer of San Francisco and they were supposed to be being provided service, and it's just that a tree came down on the line and interfered with the flow of electrons that day, you could construct an argument, and I'm not endorsing it or not.
You're saying yes, they would be entitled to power that day?
I think there would be an argument that they could, but that is so far away from what the agency has done here in saying that you can have these broad amorphous categories of consumers and that you have to look at the people who are being provided service in 1992. And they agree, you have to look at the specific people being provided service in 1992 and try to construct from that the characteristics that would define this broad amorphous class.
You think that there needs to be an analysis of every person who is being served in 1992, and then analysis of every person who's being served now, and a matching to see if they match, and then those people will be provided service. Do you think that's what's required here?
I think that you need to ascertain whether the ultimate consumer in question was provided service, and that is not hard to do. In the record, in this case, is a list of...
Is that a yes to my question? I'm asking you, how would this work? Is that what they're supposed to do?
Yes, but in the record, in this case, there is a list of customers from San Francisco from October 1992. It's not particularly long.
And I just want to understand, what are you relying on to argue that that's what was intended or what Congress wanted to have happen here?
Well, we're relying on a number of things, number of aspects of the text that I've talked about already. We're relying on the fact that this is a grandfathering provision that is supposed to winnow over time and not vastly expand over time, which is what the agency did. We're relying on the underlying...
I'm interested in your winnowing argument too. Why do you think this is supposed to winnow? Because we have this Raker Act that says that San Francisco is supposed to compete with PG&E and it's supposed to provide electricity cheaply to San Francisco residents.
So the Raker Act is absolutely irrelevant here. It does not say that San Francisco is supposed to compete with PG&E. It gives San Francisco rights of way to construct certain kinds of facilities, but it doesn't say anything about wheeling of power. It doesn't contradict Section 824.
I know, but just with respect to your winnowing argument, it seems to contradict your winnowing argument.
I don't think so, Your Honor.
There's a separate statute that seems to contemplate that San Francisco would have the ability to serve consumers. And it seems that the end game of what you're arguing is that San Francisco would have to stop doing that at some point.
Not at all.
PG&E would take over their customers?
Not at all. That is not at all what's at stake in this case. And I'd really like to explain this because I think it's critically important. Without this broad-based, class-based approach to grandfathering, San Francisco will have ample opportunity to serve consumers in lots of different ways. It will continue to generate power in the Hetch Hetchy Valley, hydroelectric power, just as it does now, and it will get that power to San Francisco consumers. And there are several different ways that that can happen, all of which would mean that the power would flow essentially as it does now. So it's not like new facilities or anything like that would necessarily need to be constructed. It's certainly not by PG&E. So one of them is the Community Choice Aggregation Program under California law, which gets power from municipalities to consumers using the utilities facility. So the power would flow as it does now. San Francisco would generate the power, and the customer would pay San Francisco for the generation and pay PG&E for the services it's providing and getting that power to the consumer. It's used all over California by many, many municipalities, and San Francisco uses it as well. It is intended to get power generated or purchased by municipalities to consumers. Another thing that San Francisco could do would be to put in intervening facilities between PG&E's distribution facilities and the end user. I think San Francisco has argued in the past that that would somehow require duplication of PG&E's systems. It would not. It doesn't require them to duplicate every line or wire that PG&E has. All it requires them to do is put some equipment in between PG&E's distribution system and the ultimate consumer, like a protective device or a disconnect switch. And again, many municipalities have done this. There are FERC cases about it, and it is not this massive, difficult undertaking. Another thing is that PG&E has made a concession in this case previously, and it's talked about a little bit in this court's prior decision, that grandfathering under certain circumstances would extend here to mid-2015, way past the 1992 date in the statute. And that's PG&E trying to make sure that this is all working well. So, and of course.
Can I ask you, like, why is it that PG&E doesn't want to wield this power?
Well, it doesn't, it's what San Francisco is trying to do here is create an unfair playing field. It wants to expand the grandfathering exception so that it can cover every customer in San Francisco, and then so that San Francisco can use the wholesale distribution tariff to get the power, that's PG&E's own facilities, to get the power to the consumers. And then San Francisco engages in rate arbitrage because it pays the wholesale rate to PG&E, and then it sets the retail rate for customers slightly under PG&E's retail rate. And the difference between the wholesale rate and the retail rate is free money to San Francisco. So the effect, the combination of those two things, the vast expansion of grandfathering under the class-based approach and this rate arbitrage that San Francisco can engage in, means that every single customer in San Francisco could become a San Francisco customer, even though it is PG&E's own facilities that are being used. So that's synthetic competition. It's not real competition. It is not San Francisco making things more efficient, more cost-effective, building anything, adding anything, transforming anything. And that is what PG&E feels is a very unfair playing field that would be created by this decision. And that, I think, is the practical effect of the decision. But I don't want to get too far away from the text.
I'm interested in understanding how you think our previous decision in City and County of San Francisco constrains our decision here. Because, of course, the previous panel didn't say what the statute means, and it asked FERC to do that statutory analysis. But there is, in that opinion, language about the importance of fairness and, competition in this context. And, the panel admonished FERC to think about its Suffolk County precedents. And arguably, FERC kind of picked up on both the holding and maybe some of the dicta of that panel opinion in issuing the order that it did.
I think it's right that the panel certainly asked FERC to take a look at the Suffolk County orders and take a look at the statute in the first instance, because the agency had not done that at that point. So that is certainly true. That's what the panel instructed. But I think that's as far as the panel's instruction went. There is that discussion at the end about fairness. And I think I've just explained why we feel like it is actually quite anti-competitive what has happened here. And that the Raker Act doesn't really speak to this and doesn't suggest that there should be some kind of mandatory wheeling of power in any way, shape, or form. And I think there's also a lot of language in this court's prior decision that we think shows that when the panel, which was not interpreting the statute, and I understand that last time, but when the panel just looked at the face of the statute and looked at its plain text, the panel was reading it the way that we read it. And in fact, that's actually doing some work in the decision. So the place that I would point to most notably is page 664 of the 2022 opinion, where the court said, any end-use customers San Francisco did not serve in 1992 could not qualify. And the work that that's doing was the court was using that to reject the argument that San Francisco's approach was too broad. And we've identified in our brief a couple of other instances of language like that I think just helps emphasize that when you just read the statute, its plain language shows that there's nothing about a class in there. There's nothing about a category type approach in there. It's just not discussed at all. And in addition,
someone who was receiving service as of the October date in 1992, but they have moved and they're still in San Francisco, but they've moved across town. Are they grandfathered under your interpretation of the statute?
so that's something that the agency did not address in the orders here, and I think is not really presented here yet. I think that would be an issue on remand for the agency.
We're trying to come up with a construction and one that is sensible and reasonable. So
Understood, Your Honor. I just wanted to flag that that's not something that the agency has decided, and they didn't decide it because they thought the class-based approach precluded any kind of location limitation. But our position about that, I'm happy to tell you, is first of all, you have to look at the point of delivery language in the tariff in conjunction with the tariff's reference to the statute here. So the tariff talks about points of delivery qualifying for grandfathering under the statutory criteria, and a point of delivery is a place, it's a physical location in the world. And so we think that when you look at that tariff language and you look at it in conjunction with the statutory language, that yes, there's the identity limitation, right? It has to be the same ultimate consumer that was getting the power in October 1992 that this case is about. We do also think that there is a locational limitation, so it has to be at the same place, the same point of delivery. But again, I think that's something that the parties would.
But your point is that the locational limitation comes from the tariff, not from the statute.
No, I think you can find it in ultimate consumer as well, actually. And so it's not necessarily just from the tariff, but I think the tariff puts a
How do
very.
you find it from ultimate consumer?
Well, the statute talks about somebody consuming power, and someone who consumes power is consuming it at a particular location where a meter is running and recording what's happening. And the commission acknowledged, this is at J56, that the utility industry commonly links customers to their delivery points. And then I think if you look at the other exception in the statute, not the grandfathering exception, but the intervening facilities exception, which talks about San Francisco putting in the disconnect switch and the protective device in between the ultimate consumer and PG&E's facilities, that is plainly location specific. Actually, we're talking about technology, physical things in the world that you can't just pick up and move around. So all of that, I would argue, suggests that ultimate consumer has this location aspect, but I do think that the tariff language puts the point on it, that it's points of delivery that have to qualify. But again, for purposes of this case, we're not talking about that. We're talking about the identity issues. And one thing that hasn't come up yet.
And so can a successor to the consumer as of October 1992 be an ultimate consumer?
So somebody who moves into a place where somebody who was being provided service in October 1982 used to live, like that kind of?
Successor as far as, I guess in the contract sense, a successor or assign, someone who takes over the contract, so to speak.
No, I don't think so. I think it has to be the same person or entity that was consuming the power in October 1992. But I think these questions about what exactly is an ultimate consumer and how do you decide exactly what an ultimate consumer is, there are some questions along these lines that are going to be questions for the agency sort of around the edges. The bottom line sort of administrability question that we were talking about earlier, I think is pretty straightforward because there is this list of customers. It's not, the list itself is not in the record, but it is discussed in the record at JA59. I'm sorry, it's not in the appendix. It is in the record, but it's discussed in the appendix at JA519. And so that's going to go a very long way to telling you who the ultimate consumers were on October 24th, 1992. I also think that the other side's administrability problems are far greater. They too will have to identify ultimate consumers to some degree to figure out whether they slot into these classes that the agency has said should happen. But beyond that, trying to figure out what the class is basically an impossible task. And that's because the word class does not appear in the statute. Congress has provided no guidance for how broadly or narrowly a class should be defined. And there's just no way to tell. And to sort of amplify on an example in our brief, if I may, on this point, imagine that the only consumer that San Francisco was serving on October 24th, 1992 was a seafood restaurant in San Francisco. And now you have to construct the class of people and entities that are like that seafood restaurant from that single consumer.
But why is it that you think that they want to expand? It seems to me that they just want the status quo. They've been serving these consumers for all this time, for decades, and they just want to continue doing so the same way they were before. Why do you think this is an expansion?
So if we're looking all the way back to October 24th, 1992, the group of consumers they were serving was much, much, much smaller. And so I don't think it's true that it's just a sort of freezing in time as of the date that the statute specifies.
Of the classes.
I'm sorry, Your Honor, I didn't quite catch that.
It seems they want to maintain the status quo of the classes that they've been serving.
Right, but
And I don't see, and I'd like you to address this because we didn't get to it before, why you think this is supposed to winnow, because that doesn't seem to be supported by anything that I've seen.
Right, so let me just start with the expansion. If you have a class that's something like every entity that has operated in coordination with San Francisco, which is one of the things that San Francisco has said that the class definitions the agency chose, then they can keep adding and adding and adding and adding people and saying, well, now this person is operating in coordination with us, this person is. And so that the group of consumers that's being served by them.
There's some connection to the municipal load or whatever. It's
not necessarily
connected to San Francisco.
Well, not necessarily, actually. I think it's actually quite unclear. So what the agency said in terms of what the classes are here was to look to the categories in this 1987 agreement, which was obviously entered into before the statute was enacted. And one of the classes is this municipal class, which they have defined very, very broadly. But there's also something called non-firm hetchy resources, which has categories in it like airport and riverbank. And so it's not just that it's purely this municipal category. And this is part of the problem with the class-based approach. It's really, really impossible to tell. What are the classes? What are their boundaries? What are the categories? And how should they be defined? So to get to your question about the winnowing, if I could, because I feel like that's really important here. A grandfathering provision by its nature, and we cited cases to this effect, it has a temporal limitation in it. And then people who are doing something or whatever the criteria in the statute is, after that date aren't included. And so by its nature, the group of people who are grandfathered gets smaller over time. People die, entities close down, there's entropy in the world.
The basis of your argument is that all grandfathering exceptions are intended to winnow. All of them are.
I think that is the basic nature of a grandfathering provision. Now, could someone write a grandfathering provision in a different way? I suppose
That's the question, whether they did that here. And it seems that when they wrote this provision, they were trying to maintain the status quo. I don't see anything about winnowing. They're trying to just keep things the way they were.
I think they were trying to keep things the way they were with respect to particular ultimate consumers who are being provided service in
That
1992.
begs the question, doesn't it?
Well, I think we've discussed in other ways the reasons why we think that's correct. But with respect to your winnowing question, if you understand the statute that way, then yes, the people are going to die, they're going to move away, and the group's going to get smaller. And that's going to put the policy, the new policy that Congress enacted in this provision more firmly into place.
Is winnowing essential to your statutory argument? I mean, winnowing may occur or it may not occur, but is the fact that winnowing may occur, or in your view, maybe should occur, I mean, is that necessary to rejecting a class-based interpretation?
No, it's not necessary. I do think it is another reason to reject the class-based interpretation besides the plain text of the statute, which again, does not say class or anything like class. And one thing that we haven't talked about yet that to me is very dispositive actually of the statutory issue, so I do want to make sure to discuss it, is the fact that there are other provisions, including another provision from the same 1992 Act that put this provision into place where Congress did talk about classes of ultimate consumers. So the main example we gave in our brief is section 111E of the 1992 Act, which says ultimate consumer or group or class, ultimate consumers or groups or classes of such consumers. And I think that tells you two different things. One is that in 1992, when Congress enacted the provision that's at issue in this case, Congress knew how to talk about classes of ultimate consumers. It didn't do it in this statute. And the other thing I think it tells you is that ultimate consumer and class of ultimate consumer can't be the same thing, because if they had been, then Congress wouldn't have said ultimate consumers or classes of ultimate consumers, because that latter phrase would have been superfluous. So classes of ultimate consumers is something different. And the other thing that's really actually interesting about that other statutory provision is for that part of the statute, there is a definition of class, actually. It's in 16 U.S.C. 2602. Class is defined to mean groups of ultimate consumers with similar energy usage characteristics. Of course, that definition doesn't apply here because the word class is in our provision, doesn't appear anywhere in our provision. And in addition, that's not the way that the agency has defined class here. The agency has defined class in this vague, amorphous way to say, well, we're going to look at the people who are provided power and we're going to pick out some characteristics having to do with them. And now we're going to somehow know what the class is. There is a massive level of generality problem with respect to that. There's no way to know how broadly or how narrowly classes should be defined.
Can I ask you about that though? What's been happening since 1992 until now when they decided to go with the tariff instead of whatever agreements? Like, how are you defining what would be covered up until this dispute arose?
Well, so the class-based approach has never been in effect until the agency's decision.
I'm talking about what has practically been happening between San Francisco and PG&E, because there has been wheeling. They weren't relying on the tariff, but how are they defining who could get wheeling?
Right. So this dispute has been going on since 2013. I will say the dispute in this case. I think I described before the accommodation that PG&E offered in this case, which was to extend the grandfathering exception to, in certain circumstances, to mid-2015, right? Way past 1992, the date in the statute, as an effort to resolve the dispute between the parties. And so the wheeling has happened under that concession for the vast bulk of the time that we've been talking about.
Just to understand how you're defining the classes, who's getting the wheeling.
Right. And so the people who are getting wheeling are, again, in our view, it is the people who are provided service in October 1992. San Francisco has disputed that, and now, under this compliance filing, San Francisco has prevailed. But this has been a dispute between the parties back and forth for this entire period of time.
So if you had a home in October of 1992 that was getting service and it was owned by, let's say, husband and wife, and they both passed on and left the home to their kids, and their kids now occupy it today, are the kids grandfathered, or are they different ultimate consumers?
So again, I think the agency can resolve some of these questions about exactly how ultimate consumer supply, but I can give you my answer as I stand here today, and maybe the agency will think something different, which is no, they're not ultimate consumers who were provided power by San Francisco on October 24th, 1992. They weren't provided power at that location. They weren't consuming the power. They may not have even
What
been
if they
in.
lived at the house in October of 1992? They've never left the house.
Oh, I see, Your Honor. I'm sorry. I didn't understand the question. Right. So in that circumstance too, I think the agency will have to address this. But in our view, if somebody was in the residence, say, on October 24th, 1992, and was consuming the power, but their name just isn't on the bill, that could be as simple as having someone just check a box saying, I lived there then, I consumed the power, even though my name isn't on the bill, so I'm not on your list of customers. I'd also point out that with respect to San Francisco in particular, there were very, very vanishingly few, I think, residential customers that they were serving in October 24th, 1992. So this issue is not going to come up in this particular case in any meaningful way. But I point out again here that the administrability problems that the other side has dwarf any administrability issues around the edges here that the agency can deal with respect to understanding ultimate consumer to mean a specific particularized ultimate consumer. And that's
Take your statutory argument to have a necessary answer to some of these hypotheticals. Is that correct?
yes, I think that's right, because there are some ways that are not at issue with respect to whether the class-based approach is correct, that the agency could address, well, what is an ultimate consumer exactly in some of these circumstances? And I think that is the kind of job that's perfect for the agency, right? That's what agencies are supposed to do. But none of that suggests that you can take the statute that says, and ultimate consumer, such ultimate consumer provided with power on a particular date, which is a noble thing in the world, and transform that into a statute that means anybody who's kind of like that ultimate consumer, even if the person you're including in that class did not exist on October 24th, 1992, was not alive on that date, was not an entity that anyone had created on that date, was living in New York or London on that date. There's no way to read this provision to encompass those folks, and yet that's exactly what the class-based approach does. It encompasses them, and that just cannot be correct. And so what we're asking the court to do here is to vacate these orders, to reject the class-based approach as an impermissible construction of the statute, and to send it back to the agency for further proceedings, which may include some discussion along the lines of what we've been talking about here.
All right.
Today.
Let's hear from
Thank you.
the other side.
Thank you
We'll give
very
some
much.
time on rebuttal.
Good morning, and may it please the court. I'm Scott Edgar for the Federal Energy Regulatory Commission. Thank you for hearing this case this morning. If I may jump in directly, Judge Pan, your questions about the naturally winnow over time, I believe that was in reply brief, page 12. I too was struck by that language, and I think this court will have a difficult time reconciling that statement in the reply brief with some of the legislative history in this case. And at footnote 124 of the rehearing order the commission discussed the legislative history, including statements by Senator Wallop. And if you look at that page of the discussion of Senator Wallop in the congressional record, he specifically refers to the idea that the purpose of this legislation, it's the next to last sentence of this discussion on this section. And he says, by the same token, legitimate existing municipal wholesale sellers may apply and obtain wheeling orders that lowers the rates for their retail customers. that is something that there's evidence in this record that Congress wanted to preserve. If you look at page 12 of the reply brief, this naturally went over time, I think, as a.
But let's deal with the text,
Yes.
not what one senator said. The text says over and over again, directly to an ultimate consumer, and then even narrows it or specifies the date. And it says providing service to such ultimate consumer on October 24th, 1992. So how on earth do we get from that, providing service on a specific date in 1992, to class that includes entities that didn't even exist or that are successors to or alike or akin to somehow ultimate consumers that were getting service on that date?
Thank you, Your Honor. I think the way the commission resolved this, and this comes from paragraph 53 of the rehearing order at JA 50, is the commission acknowledges the singular use of consumer in the section. However, the commission found that cannot refer to individual. And I think there's support for that finding. And
But
if
what
we
about the date?
we look at the
It's not just that it's a singular, but it's saying provided to such ultimate consumer on a specific date.
I'd assert, Your Honor, that the date doesn't preclude a collective use of the word consumer. And I think there's support for that. If we look at Black's Law Dictionary, 6th edition, which was the one in existence, 1990, in the latest version previous to the passage of the 1992 Act. If we look at the second and third definitions of the word consumer, singular, the second and third both use a plural word to define consumer. What the commission was doing here was using consumer in a collective sense. And and to get to your specific question about the date, I don't think that precludes that understanding of the statute. And we can talk about some of the legislative history and what Congress was really after. They were here. And in the title to this section is the idea that Congress was trying to prevent a sham wholesale transaction. And if we look at the statements of Senators Johnston and Wallop, the sham transaction comes up when it's a retail consumer that seeks to circumvent the ban on retail wheeling. Here is the very opposite of that. We have San Francisco, which has been a wholesale player in this market going way back to the Raker Act of 1913.
It seems like FERC's primary arguments are about some sort of purpose or policy or, stepping back away from the text of the statute. So what is your best argument from the text of the statute that class of consumer, that an ultimate consumer can include a generalized class of consumers?
I would refer back to what I said about consumer, that it can be used in a collective sense, and we find that from Black's Law Dictionary.
It can be, but
Yeah.
Was it in this statute?
I think so. In this context, and getting back to
But how do we know that from the text?
there's nothing that precludes that. And I would assert that this isn't precisely answered in the text. And that's why
So you're seeking some kind of deference.
we are seeking deference. And
What if deference vanishes in a few months?
that is out of my control, and that'll be that's up to the court.
Well,
But
before we get to deference, don't we have to exhaust the tools of statutory construction? The words themselves are not clear. We still have to look at context and purpose and all the other tools of statutory construction.
I would agree with that.
Before we get to deference.
I would agree with that. And I think, and I can make a case that the text doesn't answer the question, but there is support in the legislative history, and there is support in the notion of grandfathering that the commission discussed in these rehearing orders. So I do agree that you have to exhaust those tools.
And when you exhaust them, then your claim is for deference.
If there's, I don't, concede that that after exhausting them, that PG&E would win this interpretation. But if you do exhaust them and you find that there's a mixed bag, I think the current state of the law under Chevron is that the commission would get deference. But I'm willing to make that case that the plain text, as I said, does not preclude the interpretation that the commission gave. And I'll go back to what I was talking about.
But that argument that it doesn't preclude is an argument that the text is ambiguous. It's not that it's the best reading of the text. You're saying it's a permissible reading of the text.
It is a permissible reading, and I think it's also the best reading, and that the commission gave after looking at, and we can look at previous orders, the Palm Springs order, for example, that discussed Senator Wallop's discussion of what really the commission should do here is to look at substance over form. And I think all these things together, the commission has given the best reading to the statute.
The fact that elsewhere in the statute, it talked about ultimate consumers and classes of consumers.
Right.
I know that's not about this particular provision, but there is some indication. And then there's a specialized, as my colleague said, a definition of what class means in that context.
Right. Judge Rao, you're referring to section EPAC 1992. That is a comprehensive bill that has, I believe, 30 titles to it. It affects virtually all aspects of the American energy economy. Section 111 that has the contrasting language is in Title I, and that is a completely different context than Section 722, which is the subsection, which is the section that amends the Federal Power Act, something completely different. Getting back to 111, that's directing the Secretary of Energy to do something, i.e., write a report about integrated resource planning and how the states are affecting that. And I would assert that's a completely different context. And I would cite also this court's discussion in Clinchfield Coal at 895 F. 2nd 773 at page 779. And there the court deals with this expressio unius, the expression of one implies the exclusion of the other, and suggests that has a weak, it ignores other plausible explanations. So Congress might not have been thinking about this precise issue.
It's not ironclad. It's just some evidence of context. Maybe.
And I would add also, it is evidence, but I think it's weak evidence here. And I think this commission, this court's precedent bears that out. And in particular, Clinchfield Coal also particularly calls out the Chevron context and that the statutory interpretation tool is particularly inapplicable in this context.
Can you address, I'm still trying to understand, in a sense, why we're here. Why, from your perspective, what's the end game here? Why does PG&E not want to do this wheeling? Is the end game to winnow this down until they can take over all the end distributors? Or I just don't understand why this is such a, do you have a sense of what the...
I believe you're right, Your Honor, and I take the words at page 12 of the reply brief at face value. I think that's exactly
what were those words?
Naturally winnow over time. That's exactly what PG&E would like to accomplish here, and I don't.
Would that drive San Francisco out of the market?
It would. Presumably, PG&E would prefer to serve these customers through their retail tariff. Under the which would have rates presumably set by the CPUC. I do want to
because San Francisco, in order to continue serving their customers, if they can't get wheeling, they would have to build distribution networks, which they're not going to do.
That's right. That would my sense is that would be very expensive and unnecessary. And if I want to make one observation, that the question here isn't the idea that San Francisco is getting free service. It's just service under the tariff. There's a rate they're paying. If PG&E has an assertion that this rate is not recovering the cost for the service, that's a Section 205 question that they can bring to the commission. And I don't know how the commission would address that, but the commission will address it. And we'll take up those issues. So this isn't a question
Are
of,
there any rate proceedings ongoing right now about this, Sarah?
yes, there are. This is a continually ongoing dispute. And I did want to refer to, this came up earlier. The commission did point out in the remand order, paragraph 31, note 66, JA 17, that this case only applies up until July 1st, 2000. Up until the filing of the second of the rate case afterwards. And that's at JA 17 footnote.
So the power at issue that is being generated by San Francisco, is it being generated in California?
Hetch Hetchy. This is Hetch Hetchy power that was authorized by the Raker Act in 1913. And San Francisco not only operates that project, but has.
The answer to the question is yes.
Yes.
It is generated in California.
Yes.
So we have power that's generated in California. And then this is a dispute about the fact that, well, San Francisco has transmission lines. It doesn't have the distribution system to get it to each of these end users in San Francisco.
That's right.
And that's an intrastate issue, right? That normally FERC wouldn't have any role with, right?
That is jurisdiction hasn't been questioned here.
I understand that, but shouldn't that be something that should kind of impact the way that we think about this statute in this grandfather? I mean, what does FERC even have to do with this under the way that kind of the cooperative federalism model of FERC was imagined? I mean, shouldn't that have some role in how we look at what the statute means?
I'm not sure. This is a wholesale transaction that has that the commission has jurisdiction over, and I was trying to find a case that discusses that. It's Detroit Edison.
So even though it's all intrastate because it's a wholesale transaction, FERC would traditionally have jurisdiction. That's what you're saying.
Yeah, it's a wholesale transaction for distribution service, and as this court explained at 334 F3rd 48 in Detroit Edison, that the commission has jurisdiction over this kind of transaction.
But okay, so we shouldn't be concerned about that. But I guess what I'm still having trouble with, and would like to make sure that I give you ample opportunity to respond, is how text that says directly to such an ultimate consumer or to an ultimate consumer, and it says this in this particular subsection, I think it repeats that phrase 3 or 4 times, including in that last sentence. How is like this the best natural reading of that text a class and not just a consumer who was provided energy on a particular date?
Again, I would harken back to the statements about the definition of consumer and whether they can be in a collective sense. And I think, and in that sense, I would also invoke the statements of Senator Wallop and what the purpose of this provision is to allow a legitimate, not sham, wholesale purchaser of distribution to serve its retail customers. There's no question that San Francisco doesn't fall into that sort of category of, let's say, a high volume user that's upset with its electricity provider and wants to go out and to use the words of Senator Johnston, he talked about the XYZ Procurement Corporation. And so they create this procurement corporation that goes out and then creates a sham. That's the opposite of what San Francisco is. There's a long history.
Is there room in the text for a sort of intermediate position, which is the ultimate consumers were the actual, I guess, people and the points of delivery that were in effect on this particular date, and the consumer also being defined as, if it's the police department can move, it's still the police department. I just think is there some intermediate way that's more textually, I guess, supportable? That's not what PG&E is asking for and not what San Francisco is asking for.
I'm not sure, Your Honor. The way you've described that sounds like a class. If the police department is a class,
Where you can define police department as a consumer.
yes, I think so. And I do want to mention that every time in the brief there's a reference to poorly defined class or something of this sort, this is their agreement. This is PG&E's agreement, the 1987 interconnection agreement. And all the commission has done was to preserve that relationship. So I would suggest that the agreement and that their drafted agreement is sufficient to define, and there's no question about it, that was the agreement that defined the relationship on October 24th, 1992. And again, they had a hand in drafting it. So it's not exactly sensible for them to say that it's a poorly defined class when it's based on their argument, their agreement.
So if there is sort of an intermediate possibility that is more tied to the text, which would include consumers broadly defined and points of delivery that were being served at that time, if that were the best reading of the statute, are you saying that is a class-based approach, or are you saying?
It sounds like a class-based approach, and that's what the commission did. It said, okay, let's look at the date in the statute, who was being served by the entity on that date. And there's a couple ways to approach that. We can take the sort of particular individualized approach, or we can take what the commission found was a class-based approach. And the commission went through the steps of analyzing that and talked about how it would be unfair to retail consumers. I've talked about how some of the legislative history, this is going back to this.
Are you saying, I'm sorry, are you saying that regardless of what you call this, all they did was take the consumers that were being served at that time based on the 1987 contract? And that's what we're looking at here, whatever you call it?
The commission was called on by the statute to look at ultimate consumer in October 24th, 1992. The commission believed that the best interpretation of that would be to look at the class that was served on that date.
Defined by the 1987 contract.
And in this case, absolutely. And in this case, that question is answered best by looking at the agreement PG&E signed and agreed to in 1987.
Because that represents who was being served.
Yes.
In 1990. I understand. Thank you. Sorry.
So suppose we agree with you about the way that the statute should be interpreted. Your friend on the other side says that there's still in the tariff that we are, or that the commission was construing, there's still a locational restriction, separate and apart. They argue that it's also in the statute, but let's suppose, for the sake of this question, we disagree with that. What's your response to their argument that the tariff that we're construing has a locational restriction?
I think, Judge Wilkins, that the commission resolved that in the very same way the previous panel did. The commission took the position that this delivery point approach to the tariff that you're invoking here precludes the application of the class-based, and the previous panel had no problem with that. They said instead that all that language in the tariff means is that San Francisco will have to identify for each delivery point. Yes, there is a reference to delivery point, but that doesn't preclude the ability of San Francisco to demonstrate that entitlement under the tariff by demonstrating that the customer was of the class served on October 24th, 1992. So in that sense, there's no conflict there. It is possible to resolve this, that delivery point concept with the class-based approach. And I would just point out that my friend might say, well, this just means it explodes. But again, I'll go back to the 87 interconnection agreement. And so there were limits. It's not like the commission just said, anyone and in some freewheeling sense of a class, it was very much tied to their agreement. So it's not an unlimited class.
So in your view, unless PG&E has a reasoned argument that the commission's construction of the 1987 agreement is arbitrary and capricious, PG&E loses. Is my oversimplifying thing?
I think that's right, Your Honor. I think the commission his approach here was very reasonable in defining the class. Once we get to that point and say, well, okay, what was the class on that date? Commission looked at the contractual agreement in place between the parties. And I think that's eminently reasonable approach to take.
If I can just come back to this, and I'm sorry to belabor it. Are you saying, because this would address the textual argument, that the consumers that were served on this date in October 1992 are defined by the 1987 contract?
Here.
In this case?
Yes.
And in the 1987 contract, they define the users by class?
There's various definitions. There's municipal load, there's obligations to the districts, and there's a series of other things. But in a sense, that's class.
In a sense. What do you mean by in a sense?
Well, those are classes, I suppose. I'm not sure I follow the.
I guess maybe that wouldn't solve like the larger statutory interpretation question necessarily, but it just seems to me that the text seems to talk about ultimate consumers on a particular date. And there's a debate as to whether that should be the actual consumers or the class of consumers served on that date. But in this particular case, it seems that the consumers served on that date, the specific ones, are defined by an agreement, which is the 1987 contract. And that 1987 contract defines them by class.
I would say this, the statutory provision, the commission was just a reasonable interpretation by determining that a class was contemplated there, a class of consumers. Then the next question comes under the tariff. Well, how do we implement that? What does that mean?
Yeah, no, I understand that. I'm just saying, is this a different route to analyze this case, which would leave open the question of whether in all cases classes can be determined? Because in this particular case, the actual consumers were defined by class by the contract.
I think that's a fair reading of the agreement, that they are municipal load and the service to the districts. I think it's fair to look at those by class, as a class.
Thank you.
All right, thank you.
Thank you.
We'll hear from counsel for intervener.
May it please the court? Yeah, my name is Jeff Bain, arguing on behalf of the City and County of San Francisco, intervener in support of FERC. And I'd like to start with the text in the term ultimate consumer, but then circle back to some of your questions about the impact on the city and what's going on here. So I think there's some clarification I can provide on that. So I think a lot of the questions have correctly focused on what is the meaning of this term ultimate consumer. And I take PG&E's position to be that the exclusive meaning, or at least the best meaning, is it has to be a specific, individually identified retail customer, and that it has to be at the same exact location that was served on this date. And I think on its face, and our friends at FERC explained, that's not the plain reading of the term ultimate consumer, but I think the other references to ultimate consumer in the statute confirm that. And I think even if you look at section 111E from the Energy Policy Act, which we fully agree that's a totally irrelevant provision here, but even if you look at what that term's doing, it is not referring to specific individual retail customers. It's asking the Secretary of Energy to produce a study on how certain state policies affect the rates paid by ultimate consumers. And then it also recognizes there might be different effects on smaller, more narrow classes in that context. But ultimate consumer is a much broader term. And same as the saving clause at the end of subsection H that we're talking about here, where it says nothing under this subsection affects state law concerning transmission of energy directly to an ultimate consumer. The plain reading of that is not directly to Mr. Smith at 123 Main Street. It's to ultimate consumers distinguished from wholesale entities, but as a broad category of ultimate consumers. And the date, October 24, 1992, is doing work in this particular grandfathering provision, because that's telling FERC what type of consumer are you looking at for purpose of grandfathering. And that grandfathering provision functions to preserve or maintain legitimate wholesale wheeling arrangements as they existed on that date. And you might have different arrangements, and FERC applies this statute on a case-by-case basis. So
Mr. Bain, can I ask you, how do we understand the tariff language that talks about point of deliveries, right? Points of delivery for which the grandfathering criteria are met. I mean, are we here interpreting that whole tariff term or just the meaning of the grandfathering term?
I think the inquiry here is just on the meaning of the grandfathering term. I mean, the tariff, when we talk about point of delivery framework, that applies throughout the tariff. That simply means when someone's putting an application, they have to tell PG&E, this is the point where I'm requesting service. You have to meet various technical requirements, provide certain information for that point. And one of them is this eligibility requirement. But whatever eligibility requirement you apply at that particular point, that's independent from the fact that the tariff,
It is a point of delivery.
right, has to identify points of delivery. I mean, you can imagine an eligibility requirement that says you're eligible only if it's an even numbered street address, putting aside whether that's just and reasonable at FERC. You could have whatever eligibility test, it just applies for whatever the particular point is in question. So there's no inherent tension between the tariff's point of delivery framework and a class, and even PG&E's what they call voluntary accommodation to provide non-tariff service to certain of these points it seems aren't tariff qualified. That's a class-based approach that it applies under the tariff with the same point of delivery
So you've
framework.
explained why you think PG&E's interpretation is not the best one. Can you say affirmatively why you think the class-based approach is the best one without any sort of Chevron deference?
Yeah, absolutely. So it comes back to that term, ultimate consumer, which I think the various questions have pointed out. There is some question on how to define that. Requires FERC to draw a line. And going back to the function of the statute, to preserve wheeling that existed on that particular date, it asks for who was the ultimate consumer.
The statute was in part to limit, mandatory wheeling, and then it provides an exception. So those two things have to be understood together. It's not just the exception that we interpret broadly.
Right. So the question is who was the ultimate consumer in 1992? And in the case of San Francisco purchasing FERC jurisdictional service from PG&E, it was under this 1987 agreement that didn't limit San Francisco's service to particular locations. It didn't limit San Francisco's service to specifically individually identified retail customers, that agreement allowed the city to serve its historical customer base, which is a small fraction of load in the city, and that didn't expand in this relevant period from
So
92.
you're saying that ultimate consumer means whatever the 1987 agreement meant?
I think what I'm saying is you have to look at the arrangement in place at the time. So you're going to have a different class in Suffolk County, where the county was serving all residential customers in a particular service territory. That's going to be much broader than here in San Francisco, where the city has and continues, it's about 15% of the load in the city that's served by the city instead of PG&E. So what I read FERC's orders is saying is you look at the actual customers that were served on that date in 1992 under that 1987 agreement. And as long as it's the same type of customer, there hasn't been a change in the ultimate consumer.
Now, in your view, does the 1987 agreement refer to classes, the same classes that FERC is relying on?
So the way I read FERC's order is FERC didn't address each individual point. So FERC didn't rule that everything served under the 87 agreement up until 2015 is necessarily grandfathered. It asked PG&E in a compliance filing to go back, apply FERC's instructions, and classify those points. Now that leaves open the possibility that PG&E could have said, there are some points, these dozen points interconnected in the 2000s that are different than what was served on that date in 1992 under the 87 agreement. We think that's outside the class. Now, PG&E didn't do that in its compliance filing. And I think the reason is there's just been no dramatic expansion of the type of customers the cities have been serving. But I think the test FERC laid out in its decision is look at the customers that were served on that date in 1992 under the 87 agreement. And as long as you stay within that class of customers, that type of customers, there's no change in the ultimate consumer, and grandfathering still applies under the statute. So turning to the impacts, there are several points I'd like to hit. One is there was some brief mention of alternatives to how the city could fulfill its role under the Raker Act through community choice aggregation, which is a fundamentally different program that involves PG&E being the retail service provider. So that's fundamentally different than San Francisco being the retail service provider. But I think all that matters here is there's nothing in the record about this alternative of community choice aggregation. That wasn't an issue here. There's no record on why that's fundamentally different service, which it is, and I'm happy to get into. And in any event, that's not a basis for how the statute should be interpreted. I think another thing that came up was, what is the burden on the city? What would it involve if PG&E's view was to prevail? And so again, PG&E's view, exact same individual retail customer at the exact same location. And for everything else, everything PG&E deemed non-tariff qualified, it's subject to these additional restrictions. Don't just apply under the tariff, but that PG&E's never sought to apply to its other wholesale customers, even those without intervening facilities. And once one of those restrictions is triggered, the city's forced into one of two options. It either turns that customer over to PG&E retail service, or it has to install facilities to meet the other option, ownership or control of intervening facilities. And what we're talking about in this case, these are all points that were actually served under the 1987 agreement, when it transitioned to tariff service in 2015. They're already receiving power today. They're receiving it safely. There's absolutely no technical engineering reason for there to be new facilities installed. But what that does do, it imposes costs on the city to install those facilities. And the cost of these unnecessary duplicative facilities raise exactly the kind of concerns this court previously identified with PG&E's anti-competitive administration of its tariff. And that's particularly a problem given the Raker Act, given Congress's intent not just to provide a source of clean power, but also to ensure competition in the power market in the city.
So there isn't the equivalent of something like an open access tariff that San Francisco could access so that it would not have to So outside of this wholesale distribution tariff, there's not another and a similar type tariff that might have different terms, conditions, rates, but that San Francisco could access to service these customers using PG&E's distribution network.
Right. So the options would be, this is the PG&E's wholesale open access tariff for access to its distribution system. PG&E's mentioned the CCA state law option. It's not FERC jurisdictional service. It involves PG&E being the retail provider. That's not a path for the city being the retail provider. The other option is for the city to put in individual requests through Section 210 to 11 of the Federal Power Act under the same statutory criteria, just on an individual basis. So instead of having this one case about the tariff, it would be individual point-by-point cases. And that's really, I think, why this statutory criteria is pulled into the tariff, is because there's this option outside the tariff, but it would be through one-off individual applications, which obviously has efficiency, concerns on both sides, I think, on how that would be administered. But the tariff is the option for the city to be the retail service provider using PG&E's distribution facilities to reach its customers. And again, this grandfathering provision is only used for some of the city's points. The city does own, it has some transmission interconnections with PG&E that don't rely on this tariff at all. It has others that the city has intervening facilities at, often higher voltage ones that have more city facilities. And I'd also add, there hasn't been this expansion with the class of customers. From 1992 to 2015, the period we're talking about, the city's load that's relied on PG&E's distribution system had something like 2% annual growth. And that includes individual locations that grew, just general growth within the city, growth in electric usage. So there hasn't been some explosion of city service in that time. There's no reason to think, when limited to that same class of customers, grandfathering would somehow expand. And PG&E hasn't pointed to any actual examples in the record where the city has somehow stretched the meaning of grandfathering, sought to use grandfathering to serve customers that are different than what it served in 1992. And there also hasn't been any expansion in use of this statutory grandfathering criteria since the commission first articulated its approach in the Suffolk County cases, which were in the early 2000s. So I think this concern about an expansion is contrary to the facts on the ground, and it just ignores FERC's limit that it has to be within the same type of customers.
And in terms of the customers that are being served by San Francisco, can you explain that a bit? Because there was some talk about it being very unclear, like who we're talking about here.
Right. So the city's description that we've used is it's city agencies, related entities, because they're longtime customers like the San Francisco Unified School District. It's technically a separate legal entity outside the city. Tenants on city property, and some private entities providing services in coordination with the city. So it'd be like a health clinic on city property. Now, that doesn't mean the city can somehow use grandfathering to expand to any customer in the city. I think FERC clarified that in its rehearing order, where it talks about, there was some reference in the complaint to classes of customers used for different California retail purposes, commercial buildings, industrial customers. And FERC clarified, we're not saying just because San Francisco served one commercial building in 1992, it can somehow rely on the grandfathering provision to serve all commercial buildings in the city under this clause, because that's not within the same type of customers the city served under the 87 agreement on that date. That was limited to a much narrower, municipally related, some outside entities, but providing services in coordination with the city. And to the extent there were any disputes over particular points, whether they fit that would be an issue for PG&E's compliance filing, potentially a future case. But we actually haven't seen any disputes over the application of grandfathering to those kind of entities.
Thank you.
Thank you. Ms. Goldenberg, you were out of time, but we'll give you 3 minutes for rebuttal.
I appreciate it, Your Honor. Just a couple points. You can't provide service to an ultimate consumer on October 24th, 1992, if that ultimate consumer didn't exist on that date or wasn't in San Francisco on that date. But that is what the class-based approach does. It is contrary to the language of the statute. There's no broad category of consumers in the statute. It's an ultimate consumer. And so I think that's especially true because grandfathering provisions are strictly construed against the party trying to invoke them. That here is San Francisco, but it's true even without that strict construction principle. And I'd point the court in terms of grandfathering to its decision in the BP case that we cited in our brief, where the court said, when you have a grandfathering provision that has a temporal limitation, you can't say, well, somebody who didn't meet that temporal limitation maybe could have met that temporal limitation if they had been around at that point. And so we're going to put them in along with the other people who are grandfathered. That is what this court called imagining a world that never was. And that is not something that's permissible with a provision like this. And that's exactly what the class-based approach does. It imagines a world that never was. And that's particularly true about the 1987 agreement. That agreement entered into several years before the statute, is not intended to define classes under the statute. It's hard to know how to define classes under the statute.
What do you think about my question about to sort of have a better textual link between the theory that San Francisco and FERC have provided, that textually we're talking about the ultimate consumers on this date. On that date, the consumers were defined by the 1987 agreement, and the 1987 agreement defines them by class.
So I don't think that's correct, Your Honor. The 1987 agreement, again, not constructed for this purpose, has broad categories and that are also sort of vague.
Right.
Those are the
Let's
kind of
call them
consumers that
categories
could be
instead of
served,
classes.
could have been served on that date. Not that were provided service by San Francisco on that date, which is the language of the statute. And that is exactly the world that never was that the BP case is talking about. Because the 1987 agreement says Riverbank, there may not even have been a customer served by San Francisco in the Riverbank category. And that's especially true given that the 1987 agreement was amended several times over its life. It was constantly shifting. So I just think it's impossible to say that somehow this particular 1987 agreement solves the statutory problem in this case. There's going to be a lot of other cases where there is no 1987
No, I
agreement. This
understand
is
that.
going to apply in lots of other circumstances. And so I just think that what happens here under the categories in the 1987 agreement is, and the commission said this itself, this is a JA 123. It's from the commission's original order that this court vacated on other grounds in 2022. This will allow San Francisco to cover every single consumer in the city with grandfathering. The agency recognized that. And that's what this would do.
Agency recognized that if followed the 1987 agreement, that that's what it would allow.
They recognized it with respect to the class-based approach in general. And again, the 1987 agreement categories are very broad. So individuals operating in coordination with the city is anything that San Francisco wants. And San Francisco has actually argued in the past that that means customers to whom they're providing power because those people are paying San Francisco and therefore operating in coordination with them. It is
But you're saying theoretically they could do that, but what I heard your friend on the other side say is that that hasn't happened. And if that were to come up, it would be part of your compliance filing where you would say these shouldn't count. And then there would be a decision on those.
Well, again, though, I think the class-based approach is what is the problem here. The class-based approach does allow this to happen. And so we could make all the arguments we want afterwards if this court approves the class-based approach, but the class-based approach would allow them to slot these people in to these categories in the future. And the fact that they haven't done it yet, I think, is not indicative. Everyone's waiting for this court to decide whether the class-based approach is correct or not. They have made very, very broad arguments. They are also trying to push PG&E out in San Francisco in various other ways that are not implicated in this case. So I don't think we can just.
PG&E has 85% of the electricity market in San Francisco, correct?
It's approximately that, I think, yes.
And what I'm hearing from the other side is that if you were to prevail in this case, all the options that you told us that were available would make PG&E the provider, or it would force San Francisco's cost to go up so much that they would have to give you their retail customers.
Right, and I really disagree with that, and I'd love a chance to address it. So
Please.
both with respect to the community choice aggregation program and the intervening facilities. So the community choice aggregation program, as I said, is used all over California by lots of municipalities. It makes the customer a San Francisco customer with respect to the power generation that San Francisco does in the Hetch Hetchy
Served
Valley.
by who?
I'm sorry.
And they would be served by PG&E?
Well, they would be served by PG&E in the same way that they're served by PG&E under grandfathering. PG&E's distribution facilities would be used to get the power to the customer, and PG&E would get paid for what it does. But San Francisco would also get paid for what it does. So they would be a customer of both, actually. And so that's not any kind of problematic thing. It is used by San Francisco now, and it's used all over the state.
Back to why is PG&E fighting this so hard? Because what you told me before, I don't see how that harms PG&E if they're making a profit on wholesale versus retail, whatever. Like, why are you fighting this so hard?
As I said, it is the rate arbitrage that is the problem. It's taking over all PG&E customers, essentially, because it's the combination of the broad grandfathering so that everybody's covered by the wholesale distribution tariff.
So if
And then
it's interpreted to allow broad grandfathering, then you're okay.
which I think is exactly what the agency has done by pointing to these categories in the 1987 agreement and by the way it's described to the class-based approach in general. Yes.
Do you-
So, but I'm
do
sorry.
you believe that that FERC misconstrued the 1987 agreement, and if so, how?
I think FERC correctly referred to the categories that are listed in the 1987 agreement, but those categories, again, are not for this purpose. And there's no way to know whether they match up with what class means under the statute, because the agency has never explained how one would go about determining what a class is under the statute. And that's that level of generality problem we were talking about before. Not surprising, because the word class doesn't appear in the statute and Congress hasn't given any guidance on it. So, and I would also point out that the
But
agency really
PG&E
struggled here.
Agreed to those classes in the 1987 agreement.
Well, PG&E used those categories in the 1987 to generally refer to
You agreed to serve
customers.
those classes.
Well, again, I think it's not as simple as that, because it is a general reference. Those categories pop up in the agreement, but those people were not necessarily being provided power.
I understand that, but those are categories that PG&E agreed to and agreed to
But
serve.
PG&E would never have agreed to them as classes for purposes of the grandfathering exception, because they're vague, they're amorphous. PG&E would have defined things differently. They would have put a lot more care into these categories. This was a simple agreement between PG&E and San Francisco, which again, changed a lot over time, in fact. And so I just think it's extremely unfair to say that this agreement that PG&E entered into before the statute even existed is somehow now going to bind it under this grandfathering exception, when it was never intended for that purpose and wasn't written with that in mind in any way, shape, or form. And again, as I said before, the 1987 agreement won't exist in lots and lots and lots of other cases.
And is
The
that the reason that FERC gave in its order? I'm now not recollect. I mean, I think it's the 1987 agreement was pointed to as a reasonable way for figuring out what these classes were. But I'm not sure that, did FERC rely on the 1987 agreement in terms of defining the meaning of ultimate consumer?
Certainly not in terms of defining the meaning of ultimate consumer, no. FERC didn't say much at all about what ultimate consumer means. There's actually almost no statutory interpretation at
Maybe there's
all.
a Chenery problem then with them relying on that here at oral argument.
I completely agree there is a Chenery issue here, because I think the agency did not engage in statutory interpretation in any meaningful sense here. They just looked to the Suffolk County orders, which themselves engage in no statutory interpretation. The reference to the 1987 agreement came when the agency said, okay, there's a class-based approach. We've told you that now, because that's what Suffolk County says, even though other FERC orders from that era say the opposite, but that's what Suffolk County says. Now let's talk about what the classes are. And that's when they looked to the 1987 agreement, although they struggled mightily. They looked to a lot of other things too. And only on rehearing did they say, well, we looked to this exhibit to San Francisco's complaint, but maybe that's not quite right, even though those are categories that San Francisco came up with. So maybe we'll look at this 1987 agreement instead. And there was yet a third category. We're going to jettison that. They're struggling. They're struggling because there is nothing about classes here. Congress hasn't said anything about classes. Congress hasn't explained how classes should be defined. And that's the issue that they're having here, is that they're making it up because it doesn't come from anywhere in the statute, and it's directly inconsistent with the plain language of the statute.
Thank you.
Thank you, Your
Take the
Honor.
matter under advisement.
Case number 23-5076. Sault Ste. Marie Tribe of Chippewa Indians, appellant versus Debra A. Haaland, Secretary, United States Department of the Interior, et al. Mr. Dunbar for the appellant, Ms. Mishra for the federal appellees, Mr. Shah for the intervenor appellees.
Morning, Mr. Dunbar.
Good morning, Your Honor. May it please the court. The issue today is whether the Sioux Tribe's purchase of land using interest from a self-sufficiency fund created under the Michigan Settlement Act satisfies the conditions of Section 108C4 of the statute. The plain meaning of the text, as well as the administrative record before the Department of the Interior, make clear that the answer to that question is yes. Section 108C4 turns on the tribe's purpose in using fund interest, and the record before Interior shows that the tribe's objective, end, or goal, that is its purpose, in purchasing the land was to help advance the social welfare and other needs of the tribe. This property, which is called the Sibley parcel, and which is located in Michigan's Lower Peninsula, would provide a land base for the provision of direct social services to thousands of nearby tribal members. And through planned Indian gaming on the property, the purchase would create tribal jobs and establish a predictable, durable, and significant revenue stream to pay for vitally needed tribal service. All of this, it's important to note, is perfectly in keeping with Congress's design of the Indian Gaming Regulatory Act, through which Congress established Indian gaming as a calibrated means of funding tribal services and advancing tribal welfare. In the order below, Interior didn't deny that those were the tribe's purposes in pursuing the project. It simply claimed that the tribe's purpose was, quote, too attenuated. But Interior's no attenuation position adds words of limitation to the enacted text that simply aren't there. And even if there were doubt about whether Section 108C4 contains an unstated directness or immediacy requirement, the Indian canon would foreclose that reading of the statute. And with the court's permission, I'd like to focus on those 2 points today.
Can I ask you a question? It is an implication of your position in this case that the tribe could purchase land anywhere it wants, decide to build a casino on it, and the Interior Department would be required to take that into trust and allow you to build that casino?
Your Honor, yes. But let me answer it. But I'll answer yes, but explain.
Okay.
I think there is an open question that's certainly not presented here about whether the tribe could purchase land outside of Michigan. This is, after all, a Michigan tribe. It was a treaty involving 13.8 million acres of land seated in the Upper Peninsula and the Lower Peninsula of Michigan. They're all Michigan tribes affected by MILXA. I think there'd be a question, again, that's not presented here, about whether land purchases outside of Michigan would be contemplated by the statute. But you are correct.
Doesn't that circumvent, I guess, I don't know, I'm not an expert on IGRA, but it seems that there are a lot of restrictions and limits and things that have to happen before gaming can happen. And doesn't your interpretation circumvent all that, as well as the compact that says you're supposed to negotiate a revenue sharing plan with other tribes?
We don't think so at all, Your Honor. And I'm glad you've gone to the policy consequences, because I do think that over the history of this case, it's clear that Interior is really starting with its fear about the policy consequences of the interpretation and then turning to the text of the statute. So I want to address those policy consequences head on. And I think there are 3 real answers to that, and I'll preview them and then can talk about them more in depth if to Your Honor's, at Your Honor's choice. The first is that in enacting the Michigan Indian Land Claim Settlement Act in 1997, Congress would have understood that there are a variety of practical and legal restraints on having land taken into trust, as well as gaming on those properties. And again, I'm happy to talk about those in more detail. Second, I think it's also certainly the case that enacting a land claim settlement statute, some 9 years after Congress had enacted IGRA, which contained an exception that allowed gaming on after acquired lands for land acquired as a part of the settlement of a land claim, that Congress would have understood in 1997 that there could be potential interaction between the Gaming Act and the Michigan Indian Land Claim Settlement Act. And if Congress wanted to restrict gaming on land acquired as a part of the Settlement Act, it could have. And third, I think ultimately, whatever you think of those responses, the policy consequences, the fear that essentially the tribe bargained for too good of a settlement deal with Interior, which I have to say is a bit historically ironic, but even accepting that proposition, the answer would be Congress. The ball remains in Congress's court, so to speak, to restrict the tribe from some of the far-flung hypotheticals that are thrown around in the brief, endless land acquisitions, endless Indian gaming.
Or isn't the response to that we can interpret the statute in a way that avoids all this? Because I guess the provision that requires the government to take the land into trust carefully limits the spending of that money. And so if we interpret the statute that way, it avoids all of these issues that you just discussed.
I think, Your Honor, that is correct. The other side would certainly like you to interpret the statute in a way that avoids those policy consequences. But the point is, we don't think there's a textual foothold for doing so. The text that's at issue here, section 108C4, I think has three distinctive features. First, it is clear that the inquiry is the tribe's purpose in using fund interest. Purpose, as we've explained in multiple dictionaries, and I don't think is contested, means an objective goal or end.
But Mr. Dunbar, at various points, it seems the tribe is arguing that it's really the tribe's subjective purpose. So if they are planning to build a for-profit casino and allocate a very small percentage of those proceeds to charitable purposes, that is the purpose of why they're acquiring the land. I mean, don't we have to look at some kind of objective purpose?
I think I don't disagree with that, Judge Rao. I mean, we didn't mean to suggest.
A subjective purpose would be arguably inconsistent with our first decision in this case.
Well, I want to think about that and then circle back to that. But I do want to just make clear, probably to resolve the need to do so, that we're not saying it's only the tribe's say-so that counts, but certainly the tribe's purpose, its stated plans in acquiring the land ought to be a part of the analysis. And here, whether you think about it subjectively or objectively, I think there's layers of evidence that establish that the tribe's purpose in pursuing the Sibley project was not to open a for-profit casino. That was not the tribe's end. It has no intrinsic desire to engage in gaming for the sake of gaming, and no one has suggested otherwise. And so that the evidence of the tribe's purpose in this case, Your Honor, which I think goes beyond just the tribe's say-so, are the initial tribal resolutions approving the land purchase, which, as Your Honor noted, did dedicate symbolically certain commitments, earmarked commitments in 2012 for social service and other welfare purposes. The other side attempts to use that against us by suggesting that somehow we were only going to use a sliver of gaming revenue for social welfare purposes. But that, I think, badly misunderstands the context here. The tribe's board of directors in 2012 reasonably understood, like any legislative body, that it would be difficult to predict out 5 to 6 years what gaming revenues might look like, what social service needs might be of the tribe. And so it was reluctant to make specific earmarked commitments in 2012 of gaming revenues that might not be realized. I mean, we're now obviously, unfortunately, 12 years past the time when the tribe actually purchased the land. But in addition to the tribal resolution, the tribe's trust submission, the Sibley partial submission at JA 473, JA 479, and JA 480 made clear that the tribe's purpose in acquiring the land was to potentially operate gaming facilities, which would be used to fund social welfare and other services, which again is precisely what Congress intended when it enacted IGRA.
What about the fact that this statute that's before us, not IGRA, carefully delineates between the use of fund principal and fund income, right? And the only lands that can be taken into trust are those purchased with fund income for one of the designated purposes.
I think that
for fund principal, the tribe has much more leeway, arguably, under the statute. There are fewer constraints. There's a lot of discretion, left to the tribal, tribal board.
I think that's correct in a sense, Judge Rao. The one thing I would add is that I think it's significant that 108C, which governs the distribution of income, would allow the tribe to pay this money out in direct per capita or dividend payments to tribal members. Essentially private, more equivalent of sort of private wealth generation. The 108C4, which again is the statutory provision at issue here, says that the tribe can spend money for educational, social welfare, and other purposes. And in our view, a project like the Sibley project, even if it could also be characterized as economic development, when the tribe has chosen a means that Congress has created through the Gaming Act to pursue social welfare means, that fits within section 108C4. And just as a matter of plain meaning, I think our position is absolutely correct. To borrow a few just examples, someone investing money in a 529 savings plan, I don't think there would be any doubt that's for educational purposes. Someone taking money and investing that in a 401k, I don't think there would be any doubt that's for retirement purposes. Similarly, when the tribe expended here fund interest in order to invest in Indian gaming and land purchases that were carefully designed to advance tribal social welfare goals, this is similarly an expenditure for a social welfare purpose.
Carefully designed for social welfare goals when you earmark 5%. I'm not sure how.
Well,
the plan
Your Honor, I think
of
that's where
doing Indian gaming, is like primarily designed for social welfare, where social welfare is just 5% of revenues.
Your Honor, it's certainly the case that an ordinary casino, it's hard to see how that's a social welfare purpose. But in Indian gaming, I know how counterintuitive it may seem. It's precisely the case. The Supreme Court in the Cabazon Band mission decision recognized that tribal casinos are often the only way that many tribes, which don't have natural resources to exploit, have an inability to tax on the reservation because the Supreme Court has allowed states to tax, which means any Indian tribal tax effectively becomes a double tax, that many tribes have no way to generate revenue other than gaming. Congress, when it enacted the Indian Gaming Regulatory Act, recognized that reality, but it didn't create Indian gaming as sort of a private profit free-for-all. It carefully limited and ensured that revenue generated from Indian gaming would be used to advance tribal purposes, including funding vital social services, which again is precisely what our client, through a variety of means, explained to Interior throughout this long trust process. It's important to note that Interior, again, didn't reject our position on the ground that it didn't believe that it was the tribe's purpose. It simply said that purpose was too attenuated. And I think that no attenuation reading, if I may, it doesn't work for three reasons.
Can I just ask a technical question? For when you apply to have Interior take the land in trust, is that a one-time application at the time of purchase? Or in other words, because it didn't appear that you ever sought below or with us a remand in order to kind of make a more fulsome explanation or anything of that sort. Is that ship sailed, or is there any possibility of you augmenting your presentation?
There is, Your Honor, and I don't think that ship has sailed. Obviously, Interior spent 2 sentences in a footnote addressing our section 108C4 theory in the order below. And again, all it said was that was too attenuated. Obviously, a lot has been said, a lot of ink has been spilled since. If what Interior is now saying is that it simply had doubts about whether the tribe actually intends to use gaming revenue profits to fund social welfare or other purposes, I do think there's all types, we think there's all types of evidence already in the administrative record that satisfies that, but we'd also certainly welcome the opportunity to explain that to Interior with supplemental materials. But to be clear, Your Honor, I do think—
You didn't request that relief in the district court. You just said, let's go straight to senior judgment.
That's correct, Your Honor. I would think of this remand question as a remedy question, and we certainly, in all events, there are some remaining issues that Interior never addressed that would need to be decided before the land is taken into trust. So we had always contemplated that there would need to be a remand to the department, and I certainly think it would be within either this court's or the district court's equitable discretion as a remedy in an Administrative Procedure Act case to do so. But I do really want to, I'd be remiss if I didn't explain that I do think there are no attenuation theory as a matter of statutory interpretation, just has no foothold in the statute. If Congress wanted to say that the tribe could use fund interest only to directly or immediately fund a social service like benefit, which I gather is essentially the upshot of the other side's position, Congress had multiple ways to do so clearly. Sorry, Judge Rao.
Mr. Dunbar, I mean, it seems that the tribe's application focused heavily on economic development as its rationale and only somewhat relied on 108C4. And so perhaps Interior didn't give a fulsome explanation of why it rejected that. But I think that's in part because of the way tribe justified its application in the first instance.
Your Honor, it is true that the primary, we made alternative arguments. The tribe made alternative arguments in its trust submission.
Your primary argument was closed, was rejected. Correct. And so now understandably relying on 108C4, but that, to sort of nitpick at what Interior did in light of what was before it seems.
But Your Honor, I do think it probably take over time, but take all of my remaining time to list all of the places in the 3.5-year long administrative process before Interior where the tribe did make clear that the purpose of this project is to pursue and be able to fund services. That came not just in the initial trust submission, it came in the form of follow-up statements by the tribe's chairperson at the time, Aaron Payment, and this is at JA 536. He told Interior that these projects are vital to generate critically needed funds to support the delivery of service to our very large membership. He explained at JA 637 and 638 that the tribe, because of declining gaming revenues in the Upper Peninsula, was losing the ability to fund social services such as childcare, elder assistance of various types, and that without a sustained new revenue source, which again, Congress designed Indian gaming under the Gaming Act to provide, the tribe would be unable to fund vitally needed tribal services. We also submitted in a supplemental submission in 2015, an affidavit from the tribe's CFO. This is at JA 603 to 616 that explained this point concretely and pointed out that without a new revenue source, the tribe would face cuts in those coming years of $1 to $2 million in social service programs that were provided throughout Michigan. And that again, a primary purpose of the Sibley project, the land acquisition, was not only to be able to generate the funds necessary to pay for those, but also to directly be able to provide social services to the tribe's members in the Lower Peninsula. As the record reflects, there are approximately 4,500 tribal members who live near the Sibley parcel, which is outside of Detroit. The tribe currently has no trust base to be able to provide direct social services to those members of any type. To the extent they wanted to avail themselves of those services, they would need to travel to the Upper Peninsula of Michigan. Again, that was made clear time and again in the record. So I do think, to Judge Wilkins, to your question, if Interior thinks there's more that it needs in terms of an explanation of the tribe's purpose, we'd certainly be happy to provide that. But I think the record already leaves no doubt that was the purpose. Interior didn't doubt that was our purpose. It simply fixated on a no attenuation theory, or a theory that this was too speculative or indirect, that we don't think has a foothold in the statute. And even if there were some type of proximate cause like unstated limitation in the statute, I do think it's important to emphasize that Indian gaming is not a Rube Goldberg-like mechanism for pursuing tribal welfare. It is, again, precisely the mechanism that Congress created, recognizing that tribes might not have any other available means of advancing the well-being of their tribe and tribal members and paying for social services.
If you bought this land to build a school or something that clearly undisputedly falls within the criteria, and it was taken into trust, and then you sought to build a casino on it, would you have to go through IGRA, like the whole process?
It's an interesting question, Your Honor. I think at that point, I don't think we would, which again, I think the land, once it's taken into trust by Interior, would become Indian lands. I suppose a question would be whether we could game on it would then depend on whether the land was taken into trust as a part of the settlement of a land claim exception. In your hypothetical, assuming that the tribe had used fund interest to do so, I think it would qualify. But I think your hypothetical points to the fact that the tribe here was not attempting to engage in gamesmanship or pretext. From the outset, it was clear that it was purchasing this land and that it intended to use the land not only to provide direct social services to downstate members, but to build a casino on the property if it were able to do so.
My question is just, is this an end run around IGRA?
I don't think so, Your Honor. Again, the gaming consequences when Congress enacted the Michigan Indian Land Claim Settlement Act, it enacted that, doing my math right, 9 years after the Indian Gaming Act had been recognized. Congress surely understood that enacting a settlement statute that allowed for land application, that allowed for land to be taken into trust would implicate IGRA. So we don't think it's an end run around IGRA. It's simply a matter of reading together two statutes, a Settlement Act and the Indian Gaming Regulatory Act. And particularly on the circumvention point, Your Honor, Interior addressed an earlier version, a separate provision of the Michigan Indian Land Claim Settlement Act in a Bay Mills opinion. That case actually resulted in a Supreme Court case. And in that Bay Mills opinion, and this is at JA 460, in page 10 of the opinion, Interior noted that during the legislative process leading to Milks's enactment, Interior asked that Congress delete language that made the land acquisition provisions in the Settlement Act mandatory. And it also asked that Congress include a specific provision that, quote, would not repeal the limitations in Section 20 of the Indian Gaming Regulatory Act. In other words, Interior, as the purported expert agency here, recognized that there would be gaming implications, asked affirmatively that Congress include a provision in the Settlement Act restricting gaming, and Congress chose not to do so, or Congress didn't do so. And so I think, I think this is a circumstance where contorting the plain text of Section 108C4 because of feared gaming consequences just would be an unnatural way to approach statutory interpretation, given that we would assume Congress was aware of and Congress intended the interaction between the Gaming Act and the Settlement Act. If this was an unintended consequence, Congress didn't consider it, principles of statutory interpretation would still counsel in favor of fidelity to the text, and that would leave the ball in Congress's court. If somehow the Sioux tribe were able to launch a plan engaging in endless land acquisitions across the country to build casinos, Congress could easily put a stamp on those types of hypotheticals. I will say as a practical reality, Your Honor, that is any additional land acquisitions are highly, highly unlikely. Land has to be acquired for the mandatory trust provision of the Settlement Act to be implicated, has to be acquired with interest. Fund interest is a limited pot of money. It depends on the principal continuing to generate interest. There are also vast pressing needs facing this tribe, including funding all manner of social services and pursuing all other types of potential projects or economic development. So the idea that the tribe would dedicate endless resources to pursue casino operations or land into trust across the country is really lawyer rhetoric that's divorced from the reality of the situation. And I think this court can assume that if Congress understood the interaction between the Gaming Act and the Settlement Act, which it should have, it also could have understood that there are practical and legal constraints on far-flung land acquisitions and endless gaming. And again, if I'm wrong about that, or we're wrong about that, and this was just something Congress didn't consider, and it's not something that it intended to pursue, Congress can fix it. I do think it's important to keep in mind, though, that in considering these hypotheticals, the broader context here, which is that the settlement statute settles land claims for the historic unconscionable taking of 13.8 million acres of property across the Upper Peninsula and the Lower Peninsula of Michigan. So the idea that Congress would have intended a land claim settlement statute to give the tribe some ability to acquire land to be able to meet the vast and pressing needs of its members is not something I think that would be unusual or unexpected, or certainly not absurd, although no one, I don't think, has invoked the absurdity canon in this case.
All right, I think you're well over time. Unless my colleagues have any questions, we'll give you some time on rebuttal.
Thank you, Your Honor.
On behalf of the secretary, we have Ms. Mitchell. Good morning.
Good morning. May it please the court, Tina Mishra for the United States Appellees. Pratik Shah will argue for tribal and other interveners in support. This court's prior decision in this case provides the ground to reject the Sioux's secondary appeal here. The Sioux sought to use fund interest under subsection C, not for what this court called its, quote, limited and exclusive, quote, uses under the Michigan Act, and which this court contrasted with the, quote, more expansive, end quote, uses for fund principal under subsection B, but instead toward what Interior correctly found to be the Sioux's too uncertain and attenuated goal, to get land on which there might be a casino venture that may have gaming revenue, notwithstanding other obstacles like a tribal state compact, agro conditions, et cetera, for which the Sioux, there might be spending, but for the Sioux committed only 5% to what the Sioux claims would qualify as health, social welfare, and the like.
If we assume that, just for the purposes of this question, that they could build a casino, subject to all the other regulatory and statutory requirements. And if the tribe were to designate 100% of its proceeds to social welfare, would that be within 108C4?
We think that in Interior's opinion would be that it's not, and that's because there's another attenuation or uncertainty juncture that is not addressed and that has been elided a little bit by the discussion thus far, which is that even if there were to be a casino, would it be able to conduct, for example, what the Sioux called, quote, casino type gaming, which it is described as, quote, the class 3 gaming that is implicated by the tribal state compact, for example. So we think that there are multiple junctures at which Interior's determination that it was too uncertain or attenuated could be sustained as to any of those. And so we do think that this case would need to come out in Interior's favor.
I guess what I'm trying to get at is if there's some sort of economic development project that the tribe is contemplating, and it's more of the proceeds of that economic development project are for charitable purposes, would that fall within 108C4?
So as we understand the statutory language and this court's interpretation of it in the prior appeals, we don't think that that kind of downstream use is the kind of not of fund interest, but of some generated revenue is the kind of thing that's comprehended by C and C4 specifically. And the things that we would point to, for example, is as this court described, C is about, quote, uses of fund income or interest. It's not about something downstream. Talking about it as uses, as this court did in the prior opinion, kind of crowds out this subjective intent type of approach, for example, or that type of plan that the Sioux has proffered, because it also crowds out that downstream aspect, because the idea is that it needs to be educational, health, et cetera, in nature as to itself. And we think that purpose in the context of that should be understood to be use, as this court said in the prior opinion, because it's something more objective. It's not about this kind of intent or downstream use. That we think that's also reinforced by the statutory language that talks about educational, et cetera, and then says which benefit separately. We think it's reinforced by the contrast with B, which talks about economic development or these broader purposes or uses, and C does not, as this court observed before. And we think that, the other part of this court's opinion that reinforces is when this court talked about Interior's important role in this respect and pointed out that C, for example, does not have express mention, unlike B, of the tribe's role, for example. We think that also undercuts the subjective intent or kind of downstream approach to the statute. As we mentioned, there are these multiple different attenuation junctures or uncertainty junctures, as to any of which we think that Interior's determination could be sustained here. We'd also like to discuss, since there—
What if the tribe says, well, job training is very important, and so we're going to build a casino, hire, to the extent that we can, exclusively tribe members, train them, give them, skills so that they can get jobs in other casinos or in other hospitality related or gaming related fields. And to the extent that this, we don't even know if this casino is going to make any money, but to the extent that it does, every penny will go towards, healthcare or childcare or something of that nature. So they say that part of the purpose is not just to use the revenue from the casino, but also to have the casino's operation itself provide both jobs, but also job training.
So the first point we'll make is that, of course, the record here doesn't say any of that. But as to your question and the hypothetical specifically, one thing that we would point out is that the question of a job training center, those types of things, or hospital, et cetera, those are things that Interior said may be something that in a context-specific, fact-intensive way, Interior might make a determination about in the future. But that is something that could be tied up with, as we discussed, these other types of attenuation. So for example, do you project that you're going to do this down the line? That doesn't necessarily mean that it is in fact going to be achieved that you're going to do this, or likely even to be achieved that you're going to do
Where has
this.
Interior ever set forth how it judges when something is too attenuated or what type of evidence is necessary?
So as we understand it, Interior here just expressed that the Sioux's position was not something that could be sustained here as to
There are no
understanding.
regulations, there's no guideline, there's no policy document, there's no interpretive rule.
So our understanding is that this court has made interpretive rulings that we think support Interior's understanding of how the statute operates here, and it did so in the prior appeals. I'm not aware of specific regulations under MILCSA that make any formal interpretive ruling about this type of nature. But what I will say is that this case is one in which the review is for the reasonableness and non-arbitrariness or capriciousness of Interior's ultimate conclusions, applying its understanding of the statute, which we believe is consistent with this court's prior opinion. So this court could, without getting into a lot of the intricacies, could determine here that this appeal by the suit needs to be rejected and that the Interior determination was ultimately not just reasonable, but correct under just the ordinary APA review without getting into every individual instance and whether it would qualify. And that's similar to what this court did in not answering every statutory question with respect to C5 on the prior appeal as well. It didn't say, here's the test for all time, but it said, here are some things that we know do not qualify under C5, and that was what the suit had proffered there. If I may, I'd like to address the record because I do believe that that's something that also relates to Your Honor's question relating to the remand question, which, as I think is acknowledged, was not requested in the district court. It also was not requested at any time, as I understand it, in the briefing, certainly not in the opening brief's request for remedies here. But at any rate, we think that it's important that this court understand that the particular record documents that are being referenced do not actually add up to something that would make out especially any of these alternative theories about direct delivery of social services. So for example, the reference to affidavits primarily concerned, there's only really 3 affidavits in the record. 573 to 583 in the joint appendix is really only about tribal enrollment figures and spreadsheets of population numbers by county and things like that. 604 to 606 talked about primarily a conclusory statement about enhancing the Upper Peninsula land holdings. It wasn't really directed at this particular parcel in question downstate, and it was really more about a kind of gaming revenue theory. It wasn't directed at the alternative theory of kind of direct delivery of social services or anything of that nature. In addition, 618 to 619 was the only one that even really seemed to concern services. And that one, as we described in the brief, talked about there being some limited issues of housing or expressing concern, but didn't actually express affirmative intent or a plan or anything that would actually use the fund interest for any of those purposes, for example, directly. And so what we would say is that we don't think any of those alternative theories can be sustained here. We think that the position that Interior took is sustainable both from the many different attenuation junctures and also from this court's prior opinion and the reasons why that counsels for that reading. The other thing we'll just note with respect to the even possibility of a remand is that in addition to it not being requested, the Sioux here had multiple opportunities. They had multiple opportunities before Interior to supply evidence. They were requested to supply additional evidence. They've already had a first appeal even before this court on the C5 question, which to their point about concern about whether tribes can get land, et cetera. C5 is directly concerning land. That's not at issue on this appeal. It's not been appealed here. And so that's not really something that's really presented for this court. And so ultimately what we would say is that there's not much reason to give yet another round for further litigation, in particular because, as we've pointed out, the attenuation juncture that gets into Class 3 gaming and the tribal state compact and all these complexities with IGRA, et cetera. As we've noted, there are tribal interveners here. There are others who have objected throughout, and there's likely to be a lot more that would go on with respect to whether this could even get to gaming on the parcel, for example. I guess the one other thing I'll flag on the record is that I think there was some reference to JA 637 to 638. Those are also, just as we understand it, conclusory assertions of the chair, primarily about where members are and how many of them and things like that and overall revenue numbers. They really didn't make out this kind of particular alternative theory. I guess the one other thing that I would say on the record as well is that, the conclusory statements not being evidence is something that hasn't really come up here, but we think that is obviously sustainable for the reasons we've stated in the brief. And so for all these reasons, we don't think that this court could decide to sustain Interior's determination at any of these many different junctures, depending on what it chooses to decide here. We don't think that this court need to take on any more than it chooses to, and we would just urge this court to sustain Interior's determination and affirm the district court here.
Thank you. Morning, Mr. Shah.
Good morning. May it please the court, Pratik Shah for interveners. The Sioux tribe seeks to upend the Settlement Act's carefully crafted framework to procure an unprecedented expansion of casino gaming into the ancestral homelands of other Indian tribes. Having lost on their primary argument the last time around, the Sioux now evoked a charitable purposes provision that makes no reference to gaming at all. But the Sioux cannot use the mouse hole of Section 108C4 to permit the elephant of off-reservation casino gaming. That last-ditch effort cannot be reconciled with Section 108C4's ordinary meaning or Congress's explicit choice to distinguish, as this court itself described, the broader uses of fund principle authorized in 108B, including expenditures, quote, reasonably related to economic development beneficial to the tribe, which is what the casino is, end quote, versus the narrowly defined categories for use of fund interest specified in 108C. That distinction is critical given the dramatically different consequences flowing from use of those respective funds. Only lands purchased under the more limited 108C, not the broader 108B, trigger Interior's exceptional and mandatory take into trust duty.
Mr. Shaw, can you address the arguments made by Mr. Dunbar about the relationship between the statute before us here, the Michigan Land Settlement Act, and IGRA?
Yes, thank you, Judge Rao, for that question, because I think it's critical. I think the move that they're trying to make is they say, well, even if that's all generally true, economic development beneficial to the tribe is 108B, casino gaming is different because it's necessarily used for social welfare. That is not true under IGRA. IGRA provides 5 uses of casino gaming revenue. They only quote 2 in their brief. They quote the charitable purposes and the funding social services. IGRA is much broader. IGRA, and this is 25 USC 2710 B2B. It's quoted in full in our brief. That lays out what Congress has said tribes can use gaming for. Of course, anytime a tribe undergoes economic development, it's using it for the welfare of the tribe. That's what tribal governments do. That's why 108C says B says for the benefit of the tribe. IGRA maps on almost coterminously with 108B, not C. Here's what IGRA says. You can use it to fund tribal government operations or programs. That's one that they quote. 2, to provide for the general welfare of the Indian tribe and its members, not social welfare, education, health, and charitable purposes, general welfare. That's like 108B. To promote general tribal economic development. That's exactly the words used in 108B. To donate to charitable organizations, that's part of C, or to help fund operations of other local government agencies. The tribe doesn't even have to keep the money. In gaming, they can donate, they can use the funds of gaming to say fund the local police department of the city in which the casino is located because of externalities. So yes, of course, casino gaming or any economic venture entered by a tribe is for the benefit of tribal members, for the general welfare. That's very different than 108C4, which says specifically, you have to, using the no-sitter canon, right? For education, social welfare, health, cultural, or charitable purposes. That's not anything that benefits tribal members. You may use it for infrastructure. You're going to build roads, water services, all of that. That's not education, social welfare, health, cultural, or charitable purposes. It has a narrower meaning than 108B, which is anything that's to benefit tribal members. That's the critical move they're trying to make. Their record evidence before Interior was only 5% goes to that specific social welfare purpose. The other 95%, general welfare for the tribe. There's nothing in the record that commits them to using it to not building roads, bridges, not giving it to to the police department to stop crime coming from the casino, any of those things. That's well outside of 108C4. That's 108B territory, which is why Congress designed this special scheme. Anyone who knows anything about Indian law knows Congress and the tribes aren't going to negotiate an act like this and pass an act like this that is silent on gaming and then mean to back it in and allow them to open a casino near other tribes' reservations. That's incomprehensible that anyone had that in mind. And that's why 108C4 is, of course, silent about gaming. It doesn't make any sense to suggest that you could use that narrow provision to allow, again, probably the most provocative issue in all of Indian law.
Thank you.
Thank you, Your Honors.
All right, Mr. Dunbar, you were out of time, but we'll give you 2 minutes on rebuttal.
Thank you, Your Honor. 3 quick points. First, I think DOI's Interior's position here really shows that they've gone all in on a really unexplained no attenuation theory. All of the obstacles to gaming that they've identified, the potential need for an Indian gaming determination, the compact, there's not a word of an actual explanation by Interior in the trust denial order on any of this. If so the whole theory that we might never be able to game and there are too many obstacles is simply unexplained. And to Judge Wilkins' question, that alone would be a basis for a remand to the agency. We of course think the no attenuation theory has no foothold in the statute. When we speak of someone taking an action for a purpose, there is no guarantee of success requirement built into that. To take the example from our brief, if someone spends money for educational purposes or law school education purposes to take the LSAT, that money is still for those purposes, even if that student realistically assesses his or her chances at 1% of actually gaining law school admission. The money is spent for the same point. But if Interior is essentially going to claim to this court that they denied the trust submission because they feared there were simply too many attenuated steps and that the tribe might have difficulty gaming or the gaming compact, none of those issues are briefed. None of those issues were addressed before Interior. That would be a basis for a remand. Second, on the question of the delta between the permissible uses of gaming revenue under the Gaming Act and what is allowed under Section 108C4, I just have to remind the court that the statutory inquiry is the tribe's purpose. So my friend is correct that one of the ways that gaming revenue can be spent is to help offset the costs to local communities, non-tribal communities that might be related to the operation of the casino, such as roads, police. The idea that this tribe, the Sioux tribe, engaged in this particular project with the purpose of somehow funneling money to local non-Indian tribal communities, and that was the reason it undertook that project, simply makes no sense in this context. So even if we concede that there is some delta between IGRA's permissible uses of gaming revenue and what's specified in Section 108C4, but there is simply no evidence, much less has there ever been a suggestion that the tribe's purpose in undertaking this project because it wanted to funnel money to that delta. Finally, on the silence about gaming point, I think I've addressed this in my principal argument, but I would simply say that Section 108C4 is silent about all means to achieve Section 108C4 purposes. In other words, it's not a surprise that Section 108C4 doesn't say to achieve these purposes, the tribe can do X, Y, and Z, or can't do X, Y, and Z. Congress understandably left choices about how to advance the tribe's purposes, whether it's casino gaming, whether it's some other social service measure, to the tribe and to the tribe's democratically elected board of directors. So again, the absence of a specific provision for gaming has things exactly backwards when you look at the statutory text, which again focuses on the tribe's intent, its object, or its goal. And at the end of the day, we believe there is simply no basis in the record for saying that the tribe's purpose in pursuing the Sibley project was for any purpose other than advancing the needs of the tribe and its members, including social welfare, economic, educational. Thank you, Your Honor.
We'll take the matter under advisement.
Case number 23-7033, Henry Searcy Jr., appellant versus DeMaurice Fitzgerald Smith et al. Mr. Searcy for the appellant, Ms. Lee, amicus curiae, Mr. Kessler for the appellees.
Good
Okay.
morning, Mr. Searcy.
Good morning. Good morning. Your Honor, what would you do if you were contracted to take an exam, was told you failed, only to discover that the scoring methodology was arbitrarily changed, and the remedy which you was to appeal was in accordance with the voluntary labor arbitration rules of the American Arbitration Association, you only discover by the American Arbitration Association that the voluntary labor arbitration rules no longer existed, never existed. This is why I'm here today. So I'm here to argue 3 points. I've been working with the courts for 7 years on this, and hopefully I can get some resolution. I'm going to argue that Judge Walton did not consider my subsequent filings. I'm going to also argue that my state law claims are not preempted by Section 301. I'm going to also argue that the federal district court, this court, not this one particularly, but the other court in this building, is the subject matter jurisdiction, has subject matter jurisdiction over my state claim because of diversity and the amount in controversy. Therefore, as we speak right now, as I mentioned, the federal rules of procedure 11 allows for me and anybody else in this room to provide their own form of research prior to submitting a pleading. In that process, you're going to find that details change and post-pleadings change and legal theories change as well.
Mr. Searcy?
Yes, ma'am.
If you could just explain to me why you've chosen to bring these claims in federal court, because my understanding is that you're bringing state law claims
Yes.
and you don't believe that they are preempted by federal law.
Right.
And so I'm just interested in your own words, why you want to maintain the suit in federal.
Yeah, because of two things. One, because of diversity, and also two, the court, because of diversity and the amount of controversy, and the court will allow it. It's convenient for me. I'm a resident of Maryland. The NFLPA is a resident of DC. DeMaurice Smith is a resident of Maryland, and subsequent supplemental acts associated with the same incident, they can actually be allowed to be a part of the court case. So I figured this is kind of like my home field. So I want to be here.
But not in local District of Columbia courts.
No. Because it's two different actors. We got the complete diversity. Diversity is only complete if we're in two separate states. So I'm in Maryland, Bowie, Maryland. The NFLPA is DC. We got it. And now that we have I have a tort claim that I'm filing. And then because of the tort claim, the amount of controversy is satisfied due to the fact that I've, in good faith, identified in the complaint that it is over 75,000. So I just want to play on my home field. Is that okay? Thank you.
I'm sorry, why is this your home field instead of the local court?
I'm not local. I'm not from here.
Oh, I see.
So I'm not from DC. So, but I do want DC law to apply.
I see.
Yeah.
Oh, I see.
Yes, ma'am. Because it's favorable for me. It's like playing in your home field again. I'm very knowledgeable of the things. So DC law is actually governed by Maryland law too. So, I shouldn't tell you that, but so it's going to provide an opportunity for my case. So nevertheless, let me get.
Do you fear that they'll be biased against you in the local court because you're not from DC?
Only person biased against me is Judge Walton so far. I think I'm acceptable anywhere now. And I think the facts and statements that I'm saying are just pretty plain and simple. I just need someone just to listen to them and quit adding stuff to the process. So this is the second time I'm here, by the way. I don't know if you know. I actually, and so I'm back. But I'm back because Judge Walton did not do what this court told him to do. He told him to review and provide a ruling on my state law claims. He did not. So that's why I'm here again, just to make sure that he does exactly what he's supposed to do. Maybe you can, whoever was in the panel last time didn't make him do it, but they told him to do it, but he didn't. So I'm hoping he can do it this time. Nevertheless, are there any other questions? Okay, so one of the things I have a challenge with is that, the case law of Ms. Carty. Ms. Carty is a CVS pharmacy person. She was a pro se litigant. She as a pro se litigant, this little lady, she actually submit subsequent filings complaining about her systemic internal acts that cause her distress. The court considered her pleadings broadly, and so broadly that Ms. Carter's complaint was identified as another claim was added as an intentional infliction of emotional distress, just because of her subsequent pleadings and because she was a pro se litigant. However, when it comes to me, I am a pro se litigant. I actually submitted legal theories and changed my legal theories just like Ms. Carty. However, my legal theories were not considered. They were not considered at all. The record would show that my subsequent pleadings stated that the NFLPA and DeMaurice Smith was in violation of the DC Arbitration Act. The record would also show that I filed a federal civil procedure, section 15A2 with the court to require justice to be served because the requirements does that. And because justice so required, the NFL, because justice so required, and the reason why it was required because the NFLPA attorney and DeMaurice Smith attorney admitted to breaching the contract between the appellant and the NFLPA. That was put in writing. The record would show, as according to the federal rules of evidence, that both the NFLPA and DeMaurice Smith attorney, which is Angela Smedley of Winston and Strong, stated in the subsequent filings that, and I quote, "There is no genuine dispute as to any material fact that the NFLPA breached the contract between Cersei and the NFLPA. The motion does not mention Smith," end quote.
Do you want to reserve any time for rebuttal?
I think 1 minute.
Because you got 2 minutes left.
Oh, Lord, okay. I don't get first because of questions? Okay, the appellant was not, so therefore, the record would show that the NFLPA attorney Joe Briggs' affidavit and the discovery response provided to me during the American Association appeal hearing, which was not an appeal hearing associated with the American Association. He provided appeal hearing according to the voluntary, he provided an affidavit that admits that the NFLPA changed the scoring methodology. In that affidavit and in those responses, he identified that the Players Association did not ratify the contracts because he said that there were no ratified bylaws or meeting minutes approved to change the scoring methodology. He also said that the NFL paid, in that affidavit, it states that the NFL paid Prometric to change the scoring methodology on the NFLPA contractor exam, and the appellant was not provided an appeal hearing. Therefore, another thing I'm going to say is that state law claims are not presented by Section 301. The reason why is because the Article 48 of the NFLCBA contract does not consider any applicants. I'm an applicant. I'm not a certified agent. Applicants are listed in the contract between prospective agents and the NFLPA, but only people that are privileged to the NFL collective bargaining agreement are those that are not applicants, that are certified contractors. Section 2 of the NFLPA contract states this, and it also identifies the applicant. Therefore, a ruling should be done for me as an applicant, not a certified contractor.
All right, thank you. We have your argument. We'll hear now from Ms. Lee, court-appointed amicus curiae.
Thank you, Your Honor. Erica Hashimoto from the Georgetown Law Center is court-appointed amicus. With the court's permission, third-year law student Alexandra Lee from the Georgetown Law Center's Appellate Litigation Clinic will present argument on behalf of amicus.
Thank you, Ms. Hashimoto, and welcome, Ms. Lee.
Your Honors, may it please the court. When Congress enacted Section 301 of the Labor Management Relations Act, it authorized federal courts to create uniform federal common law governing labor contracting. Congress made clear in the statutory text that Section 301 implicates only those labor contracts between an employer and a union or between two unions. Consistent with the scope set out by Congress, the Supreme Court found two separate paths to preemption, with one important limiting principle, that preemption applies only where the interpretation of a 301 labor contract becomes necessary. The union's position contradicts both the statutory definition set out by Congress and the limiting principle fashioned by the Supreme Court. I'll first explain why the regulations are neither a 301 labor contract by itself, nor a part of the collective bargaining agreement between the NFL and the Players Association. And I'll move on to why this court must uphold the limiting principle and require an interpretation of a labor contract to find preemption. First, the text of Section 301 is crystal clear. A labor contract has to be one between an employer and a union, or between two unions. The regulations is an agreement between the Players Association and Mr. Searcy, and it simply doesn't fit within the statutory definition set out by Congress.
What about the Black decision in the district court that seems to support what Judge Walton did here?
Your Honor, we're asking this court to overturn the Black decision precisely because that decision overlooks the clear statutory language defining what a 301 labor contract is. So the regulations by itself is not a 301 labor contract. It is also not a part of the collective bargaining agreement. Because the NFL and the Players Associations agree that only the union will get to set the standards for selecting agents, and the NFL will have no part in it. And so consistent with that contractual design to place certification beyond the reach of the NFL, the CBA never mentioned the regulations by name, and it also never expressly incorporate the regulations by reference. And because the regulations are not a labor contract, nor part of the collective bargaining agreement, Section 301 preemption is only possible here if this court needs to interpret the collective bargaining agreement to resolve Mr. Searcy's claims. But that.
Let me ask you a question. So it seems to me that there are two competing principles at here with respect to jurisdiction. One is that a plaintiff who wants to bring their claim in federal court has to establish that there is subject matter jurisdiction. And so arguably Mr. Searcy has failed to do so here because there's not complete diversity and and he's only bringing state law claims, not a federal law claim. So in that context, why should we be thinking about 301 preemption at all to establish jurisdiction? I mean, this isn't a removal case. It's not a case where originally the claims were brought in a state court or in the District of Columbia courts.
Your Honor is exactly right that Section 301 preemption cannot serve as a basis for federal question jurisdiction. And because there's no other basis that would provide federal subject matter jurisdiction, that we're asking this court to reverse the district court's finding.
My question is not necessarily about the merits of whether 301 preemption applies here, but rather whether we should be considering the 301 preemption question at all in this posture.
Your Honor, I'm not sure I understand your question, but our position is that if the union is concerned with its ability to select agents, plaintiff could always raise these claims in state court. And Section 9A preemption under the National Labor Relations Act is always available for the union to use as an affirmative defense. And so these claims are properly brought and should proceed in state court.
So aren't we considering preemption under 301 because this court remanded for the district court to decide that question?
Yes, Your Honor.
So just procedurally, this is a little different from a case where the court just sua sponte starts looking at preemption based on what the plaintiff or the appellant argued. Isn't that right?
Right. I think my recollection is that previously the district court dismiss this case under 12B6 of the Federal Rules of Civil Procedure instead. And the issue on appeal is whether the district court has subject matter jurisdiction to dismiss the case under 12B6 to begin with. So it's a matter of whether this court dismiss under 12B6 or 12B1.
Thank you.
So
And the significance of that for Mr. Searcy would be if it's dismissed for lack of jurisdiction, it's dismissed without prejudice. Versus if it's dismissed on 12B6 grounds, it's dismissed with prejudice.
yes, Your Honor, and Mr. Cersei is free to bring his state law claims in the DC Superior Court, and that case would probably proceed in state court. There's also no preemption here because Mr. Cersei's claims require this court to interpret only the agent regulations. So the Alice Charmer preemption test provides two paths to preemption. A plaintiff could either raise a claim that's substantially dependent upon the interpretation of a labor contract or inextricably intertwined with the interpretation of a labor contract. And so here, Mr. Cersei makes two broad factual allegations. His first allegation is that the union failed to amend the regulations to reflect the changes they made in the exam procedures. And for that allegation, this court has to turn to Section 1C of the regulations. His second allegation is that the union did not comply with the arbitration procedures. And so for that claim, this court has to look at Section 5
So the
of the
collective
regulations.
bargaining agreement, Article 48, Section 1, does have quite detailed discussions about the NFLPA's obligations about deleting an agent from its list with a lot of just very detailed circumstances that they have to consider. And it also says the NFLPA shall have sole and exclusive authority to determine the number of agents to be certified and the grounds for withdrawing or denying certification of an agent. So why is this not intertwined with that?
Because first, Mr. Cersei's claims are sufficiently removed from whether the union indeed has the power to promulgate the regulations or to determine the grounds for certification. So his claims are essentially that when he applied for certification, the agreement is that the union would conduct the exam and the arbitration according to the regulations, but they failed to do so. So it's about the nitty-gritty of how the union went about certifying him, and not about whether the union indeed has the power to conduct exams and to certify agents. And I want to address the gravamen of the union's argument, which is that because sports unions operate differently in their collective bargaining agreement, then Section 301 preemption has to apply to protect the union's ability to select agents. That concern is certainly important, but that should not drive this court's Section 301 preemption analysis. The union's ability to delegate its exclusive bargaining power to certify agents flows directly from Section 9A of the National Labor Relations Act. And a Section 9A concern is properly addressed by Section 9A preemption, meaning that the union can raise Section 9A as an affirmative defense in state court to insulate itself from any state law claims. And I want to point out that a built-in mechanism to ensure that the union gets the say-so of selecting agents is arbitration. So under the regulations, disputes over certification has to submit to arbitration. So arbitrators, not state or federal courts, would interpret the regulations in the first instance.
All right, Ms. Lee, your time has expired. If you want to just say a couple words to conclude, we'll give you some time on rebuttal.
Yes, I can reserve the rest of my time for.
All right, thank you.
Thank you.
All right, we'll hear from Mr. Kessler on behalf of Appalese.
Good morning, Your Honor. Let me start with Judge Pan's question. We agree, as your question at least suggested, that the detailed obligations the union assumed in this CBA to have an agent regulation system, to apply certain rules in that system for both certification and denial of certification, makes the regulations sufficiently intertwined with the CBA that it fits right into the complete preemption of Section 301 as articulated in the statute. And that's not limited. The issue is not just whether it's a CBA issue, but whether there's a labor contract involved. That's what retail clerks make clear. When you look at the policies of complete preemption, what are the policies that are there? Has Congress so regulated the area that we can't have individual state courts making these determinations because we need a uniform national regulation? That applies directly to this type of agent regulation system, which was correctly pointed out comes from Section 9 of the National Labor Relations Act. When you look at that, the combination of that statute, and you look at the Supreme Court's decision in H.A. Artis, which talks about that in entertainment and sports unions, where you have this delegation, the agents are themselves labor parties.
Mr. Kessler,
Yes.
if you could respond to the question that I asked Ms. Lee, why do we need to think about complete preemption in this context? You know, where the plaintiff arguably has not demonstrated federal subject matter jurisdiction. I mean, maybe it has to go back to, you know, or maybe those claims need to be brought in a state court.
So
where complete preemption is then.
I'll answer both procedurally and substantively, if I may. Procedurally, the prior order of this court
Well, I understand.
created this issue, I think.
Well, it asked
with-
about this issue. That doesn't
Right.
mean that issue is one we have to decide.
Okay, so then moving on to, that's sort of procedurally why we're here, but substantively, if this case were filed in state court or in DC local court, we would remove. And when we would remove, we would be back in the federal court. The issue would be here, maybe come up here again. And really in sympathy with Mr. Searcy, he's been doing this for 7 years. He'd like some resolution. I think now's the time to get that resolution, whatever the court decides, rather than say, we're not going to decide it, have it go back. He either files again in local court, we remove, then Your Honor would agree, because we're going to argue complete preemption, so it does remove it, and we're back up in exactly the same spot. So
Can you point to cases where a court uses complete preemption to establish federal subject matter jurisdiction in the first instance?
sure. Actually, not all the cases, but some of the cases we cited. So for example, one was the Weinberg case in the Northern District of Texas involving these regulations. It was removed to the Northern District of Texas. That was first filed in state court and
That's
complete.
in the context of removal. I'm saying not when there's no removal, when the initial claims are brought in federal court, and then the federal court uses complete preemption as the basis for its subject matter jurisdiction.
So I don't know of a specific case, but the reason why it doesn't come up. So the parties being sued in these cases are either the union or the employer, right? Those are the two labor parties or related labor parties. Those two, we don't agree about a lot of things, but the union and the employer always agree we should be in federal court because we need a national body of law to have consistently do this. Imagine if we had an agent regulation system and some agents did have to pass the test if they're in one state, and some agents with another state didn't have to pass the test, how could we delegate our labor authority under that? So we need this type of uniform system. That's why every district court that's looked at this, and so it was Black, it was Weinberg, it was Poston, the decision below, when they look at it, they go say, yes, one way or another, whether it's under Section 9 of the NLRA, which I also believe, by the way, can be complete preemption. I want to raise that point. It was noted this court's decision in Exxon said there's only 3 identified by the Supreme Court. That's true, but the Supreme Court has not ruled that the National Labor Relations Act couldn't be added to that list. The way you would decide that issue is you look at the decision in Condon, which says there's preemption. And what Condon says in the Supreme Court is that it's a total occupation by Congress to give total regulation over how unions control themselves and delegate their exclusive authority. So if you apply the principles of Condon and you apply the principles of H.A. Artis, which note this special relationship in the labor parties, you come to the same complete preemption result on this either Section 9 of the National Labor Relations Act or under Section 301 of the LMRA for the reasons identified by Judge Pan. I think the way the court should look at that again is, has Congress comprehensively regulated this issue of unions delegating to agents? No one disputes that. Amicus agrees with that. That is 100% clear. We couldn't anymore have our delegation of authority if we couldn't regulate the terms. For example, we have regulations about that they can't have criminal records, they can't commit fraud, they can't deceive the players. All of that has to be done on a national basis, so we couldn't have this delegation of authority with respect to that. So when you look at it that way, when Congress is done, we at least believe that under either statute, there's complete preemption, and under either one, we should be in this court, and all of us should have some final resolution of this after 7 years of doing this. So unless Your Honor has any questions for me, I don't usually stop with time left over, but I feel like I've made the points that I would like to make.
Thank you.
Thank you.
All right, Mr. Searcy, you were out of time, but we'll give you 1 minute for rebuttal.
Okay. In addressing some of the discussion that was had, the court, another reason why I should be here, because my claims are over $1 million. And that's another thing. Also, U.S. Constitution and Congress established 2 requirements to allow for federal courts to hear cases in this court. And so those 2 requirements I've identified. The next thing is that the NFLPA regulation has a 2-track. There's an applicant track and there's an NFL agent track. The reason why you look at the collective bargaining agreement, you see all those discussions about agent or contract advisor. That's Costco. I'm an applicant. I can't get in Costco. Okay, I'm an applicant. So I had to sign a contract just to satisfy the contract. And that contract said in Appendix A, I further agree that this application for certification, if one is issued to me, along with the NFLPA regulations, shall constitute a contract between the NFLPA and myself. I'm an applicant.
If this case were to be dismissed for lack of jurisdiction, that would be without prejudice. And that means you could bring it again in the DC Superior Court. And I just wanted to note, I was a judge on the DC Superior Court for 12 years, and I have every reason to believe that you would get a full and fair hearing in that court. They are accustomed to cases like this involving litigants who are from Maryland or from Virginia and, you know, have a case in DC. And they're very accustomed to dealing with pro se litigants such as yourself. And so I just wanted to note that you had said you brought your case here because you thought it was your home court. And I hope that you'll consider that if I'm not saying it will, but if it were dismissed for lack of jurisdiction, you could bring it again in Superior Court, and you would get the kind of law that you want applied, which is the DC law, and they are very experienced at applying that law. So I just wanted to note that for the record.
Thank you, Mr. Searcy. Ms. Lee, your time was expired, but we'll give you a minute for rebuttal.
Your Honors, I have 2 points to clarify on rebuttal. So inextricably intertwined doesn't mean that the regulations and the collective bargaining agreement are inextricably intertwined. It means that the resolution of Mr. Cersei's claims has to be inextricably intertwined with the interpretation of a labor contract. And that's the only way that there would be Section 301 preemption here. Second, the union explicitly kept the certification process out of the reach of the NFL, and in doing so, removing it from the purview of Section 301. And that is the process that the union bargained for and agreed to. And this court should not expand the scope of Section 301 preemption to accommodate what the union bargained for, but now decided that it doesn't like. If Your Honors don't have any more questions, I'll cede my time. Thank you.
Thank you, Ms. Lee. You were appointed by the court to assist the appellant and assist the court as amicus curiae in this case, and the court thanks you for your assistance. The case is submitted.
The Honorable Court of Monday, 6 at 9:15.